Courtmaster, am I audible? Can somebody please confirm? Am I audible?
Yes, sir, you are audible.
Thank you, madam.
ಅದು ಇವತ್ತಿಂದ್ರೆ 20th. This disparity I don't understand. 2:30 or 20th? How is this even possible? Give it, yes.
My lord, one matter per 2:30, my lord.
Give it 20th ಗೆ ತಗೊಳ್ಳಿ.
One matter per my lord, 2:30, my lord. 2:30, my lord. Tender matter, my lord, in the.
Tender ಕೊಡಿ.
Mil-
Elections ಕೊಡಿ.
One pending matter, my lord. It was last heard in March. We are moving memos, but
ಬೆಂಗಳೂರದ
illide.
next week.
Monday, my lord. Kindly be taken up on Monday, my lord.
No, not on Monday. Monday there are already 200 matters now.
My lord, date matter, lord.
Give it, but next week.
Date matter, my lord. Date was given today, but it failed to list, your lord. Kindly on Monday.
Monday or Tuesday will come. Give it, please.
Lords, one matter at
2:30 act. Why 2:30? Huh?
Lord, tax matter, my lord. 3 matters.
Monday.
On 19th, your lord.
Oh, it's 19.
Minutes on fresh matter at 2:30 minutes. So cause notice has been issued minutes. They are trying to record the amount minutes from the petitioner. Date was given today itself minutes on the.
Monday ಕೊಡಿ.
No minutes. Senior has
ಏನು?
come minutes. Minutes one submission.
Showcause notice ಗೆ urgency ಏನಿದೆ?
Same tax matter minutes today. All matters have been listed. 2:30 minutes.
2:30 ಇಲ್ಲ, Monday ಬರಲಿ. Monday, take it on Monday. Yes.
One matter at 2:30.
Successful inquiry is being held on removal of Mutawalli tomorrow.
Tomorrow? You're coming tomorrow?
In Karnataka State Board of Hawka, tomorrow they have given date for
2:30.
One matter, service matter. Already notice issued, my lord.
Next week.
One matter, my lord, at 2:30. My lord, consumer forum has issued warrant, and my lord, matter is posted at 17th.
Lords, one matter for 2:30.
Why?
She's a old age lady, my lord.
ಅದಕ್ಕೆ 2:30 ಈಗ?
My lord, only consider
My
matter.
lords.
Mind ಮಸ್ಸ.
Only because
This is what you are abusing the jurisdiction.
her health is not good, my lord. So,
Monday.
not many times I moved.
Monday, sir.
My lords, one fresh matter for 2:30, my lords. The petitioner's was deported from the city for the offences committed in previously, my lord, sir. And the marriage was about to taken place. So
What are you saying?
they are deported from the city, my lord.
Amendment.
Yes, please, my lords.
Give it Monday.
2:30, my
Not
lords.
Lords, one matter on
My
Monday.
lords.
tomorrow I will not grant.
Lords, one matter on Monday. Police protection. Already this court has issued a
Monday
notice.
give it.
My lords, one matter for Monday,
Tuesday,
Give it.
please.
one matter for Monday, my lords, vacating interim order, entire requirement notification,
Tuesday.
please.
Lords, several writ petitions, my lords, on the point of lighter duty, depending upon, my lords,
ಹೌದು.
there are, my lords, around 70 cases covered by the judgment of
70.
70.
ಕೊಡಿ.
My lords,
ಅದು ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಮಂಡೇಗೆ ಹಾಕ್ಸ್ಬಿಡಿ ಮೇಡಮ್.
Monday.
Tuesday.
ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕ್ಸಿ.
Tuesday it may be.
Convenient to the court.
ಮಂಡೇ
Tuesday
ಟ್ಯೂಸ್ಡೇ
it may be taken up, Lord. Tuesday it may be taken up.
ಆಯ್ತು ಮೇಡಮ್, ಅದು ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಆಲ್ 70 ಮ್ಯಾಟರ್ಸ್ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕ್ಸಿ. ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್.
Please.
Please, Lord.
Let's make one
ಆ ಥರ
mention.
ಯಾವ್ದಾರು ಇದ್ರೆ ಹೇಳಿ. Close ಮಾಡಿ.
In fact, few matters, my lords, regarding suspension order that is challenged.
ಅದೇನಾಯ್ತು?
4 matters are listed today. There are other 4 matters. I'll give the numbers. Maybe we can have it on Monday or Tuesday. Please.
Let's one mention, my lords. Your lordship have heard and reserved that tax matter, my lords, 1,38,000 of.
Tell him.
Please, my
I'll
lords.
give Monday.
Great.
Tuesday will do.
Great.
So yesterday's that recovery certificate issue, ma'am.
Sugar.
Sugar.
ಬಂದಿಲ್ಲ ಇವತ್ತು.
ಬಂದಿದೆ 57 and
2:30ಗೆ ಅದು ಕೊಡಿ. ಎರಡು 2:30ಗೆ ತಗೊಳ್ಳೋಣ.
serial number 57 and
ಅದು
55.
ಈಗ ಮೂವ್ ಮಾಡ್ತಿರೋದು ಎರಡು ಸೇರಿ 2:30ಗೆ ತಗೊಳ್ಳೋಣ.
Already list ಆಗಿದೆ.
ಆಗಿತ್ತು ಅದು. Okay, fine.
Serial number 73. 1 week's time is given
We'll
for
see. Mention when it is,
furnishing
mention
the
when it is called.
immediate copy of.
Mention when it is called. All the cases.
One submission. 115 and 116 in fractures, my lord.
15 and
115 and 116, my lord, in fractures, my lord.
115 and 116. Counsel for the petitioner submits that the petition is rendered infructuous due to efflux of time. In the light of the said submission, petition is disposed as having become infructuous.
With my lord, kindly, my lord. My lord, serial number 106, my lord.
Adjournments when the matter is called. Yes, call the case.
Lord, serial number 74, we have filed memo for withdrawal.
Thank you. Yes, withdrawn in terms of 74 in terms of memo.
Number 1, B.V. Bajantri, Vijay Kumar.
For the petitioner, Lord, by the impugned endorsement, my lord, 3 sections which were approved, Lord, are sought to be rejected under the salary
Yes,
grant.
madam, some problem with the approval.
Your Lordship, we have filed detailed statement of
ಹಾಕಿದ್ದೀರಾ?
objection. ಹಾಕಿದೆ ಸ್ವಾಮಿ, ಅವಾಗಲೇ ಹಾಕಿದೆ.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರಿಗೆ?
ಕೊಟ್ಟಿದ್ದೆ.
Yes, Lord, I have got it.
Yes, sir. What do you say?
My lord, those orders are not applicable to my case, my lord, because the sanction was granted, my lord. Approval of additional section was granted, my lord. I have produced along with the memo with document on 7/1/25. But the approval was for 8th standard was additional section was granted on 28.
As per my instructions, Your Lordship, no sanction has been granted.
Where is the document of
Last time,
sanction,
Your
sir?
Lordship.
Lord, I have produced along with the memo, my lord.
Which is that?
Along with 7/1/25, my lord.
I know.
Last time, Your Lordship.
page ಹೇಳಿ.
My lord, first page. That is 8th standard, my lord, on 28/2/2006.
ಮೇಲಿನ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖದನ್ವಯ ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿಸುವಂತು ಪ್ರೌಢಶಾಲೆ ಶಾಲೆಗೆ 2006-7ನೇ ಸಾಲಿನಿಂದ ಅನ್ವಯವಾಗ 8ನೇ ವರ್ಗದ
ಒಂದು ಹೆಚ್ಚಿನ ವಿಭಾಗಕ್ಕೆ ಕನ್ನಡ ಮಾಧ್ಯಮದ ಶಾಶ್ವತ ಅನುದಾನ
ಅನುದಾನರಹಿತವಾಗಿ.
Yes, madam, it is approval. Subsequently, I have been sought for inclusion under the salary grant.
ಸಾಲಿನ ಮನ್ನಣೆ ನವೀಕರಿಸಿಗೊಂಡಿಗೆ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ.
Yes.
Last time, Your Lordship, our officers were present, Your Lordship. They denied, Your Lordship. They said.
They deny alla what document? They may deny anything.
Please, Your Lordship.
What is this?
No approval has been granted, Your Lordship.
What is this?
ಇಲ್ಲಿ ಅನುದಾನರಹಿತವಾಗಿ ನಡೆಸತಕ್ಕದ್ದು. No grant has been granted, Your Lordship.
But initially they have granted
ಅನುದಾನರಹಿತವಾಗಿ
ಶಾಶ್ವತ
ಅನುದಾನರಹಿತವಾಗಿ ನಡೆಸತಕ್ಕದ್ದು, Your Lordship.
Not as, my lord, subsequently, my lord, I have sought for inclusion under the salary grant, my lord.
No. ಈಗ you said permission is granted.
For start commencing the additional section.
All right. Commencing 8th standard, the class permission is granted from 2006-7.
Yes.
That is without aid.
Yes, ma'am. Subsequently, my lord, your lordship may kindly see next page, my lord. On 10/1/2007, they have granted permission for, my lord, 9 and 10 also, my lord. additional
right,
section.
again,
My
without.
submission is this, my lord. After my college school was not brought under the salary grant as on the date when 28/2/2006 was issued. Subsequently, my lord, in 2007, 7/4/2007, my lord, when the proposal was submitted, my lord, they granted only in respect of, my lord, 1 to 7, and additional sections they have not approved.
So
Not the-
as on today, there is no grant order for 8th standard.
Yes.
No. Lord, as on today, there is grant order for one section of 8, 9, and 10.
Which
These
section
are
is
additional sections.
Which section is this?
For additional section,
Additional
there is no
section.
grant, your lordship.
Lord, your lordship may kindly see the
No,
rule also
you
permit.
show me a document that for additional section also there was grant.
Your lordship may kindly see page 44, my lord. But annexure 4, this is 1999 rules, my lord. Standard staffing pattern for high school. The lordship got it, my lord.
What is now come to your prayer at page 9?
Yes, ma'am.
To consider proposal dated 22 seeking salary grant for 18 teaching and 7 non-teaching. Where is the question of that?
My lord, actually, my lord, what has happened is, my lord, when I submitted the proposal, it was including the 3 additional section for 8, 9, and 10. They had sanctioned, my lord, salary grant only for one section each of 8, 9, and 10, and therefore, my lord, I am before this honorable court, my lord, seeking that when the approval was granted to commence the additional sections of 8, 9, and 10 by the competent authority.
Where is that additional section approval granted?
That is what the granted approval is I have produced along with the memo.
No. Adu one section matra.
Even next one.
Where is additional section 8, 9, 10 approval granted?
Yes, my lord, your lordship, along with the memo, first page is one additional section of 8th.
Ashte.
And next, my lord, 9 and 10 also, my lord, they have approved. 10/1/2007.
That is all without grant.
My lord, all are without grant only, my lord. Subsequently, I submitted a proposal along with the additional sections on 7/4/2007, my lord. And that has been approved only except these 3 additional sections.
Yes, madam.
Your lordship, for the additional sections, your lordship, the attendance should exceed 70% in the original section, your lordship, and further for additional sections, your lordship, over and above the first additional section of 70%, your lordship, 70 students, your lordship, and they have not taken the permission from the concerned.
Have you said so in the objections?
Please, your lordship.
Lord, in the objection, they don't say so.
Rejoined hakongidre haki. Wilder will dismiss it. Yes.
Lord, your lordship may kindly see. I'll file the rejoinder, Lord. The government order which they are relying on is not applicable to my case on hand.
Rejoined haki.
Yes, my lord. Your lordship may kindly come to the document which they have produced that page. Annexure.
Where is the rejoinder?
Lord, I have filed a rejoinder, my lord.
There is no rejoinder here. Yes, list on 27th, rejoinder if any by the next date. Yes, next.
Your lordship, in this matter, your lordship has directed me to get an affidavit, your lordship. Affidavit has been received, your lordship. I'll submit it. Kindly pass over.
What affidavit?
The respondent number 4.
Residential.
She got appointed for the Anganwadi worker post. But however, at the time of applying for the post, she did not file the residential certificate because she tells
CDP was directed to cause
she was
inquiry
residing with a grandma in that place for 10 years.
Pass over.
Monday preliminary hearing. Yes.
Please. Fresh.
Monday preliminary hearing.
Great.
Number 3, SG Solar Gopal.
I appear for the petitioner, my lord. I appear for the petitioner in this case. Yeah. I seek a short accommodation on Tuesday 18th, my lord.
2015, sir.
Tuesday 18th, my lord.
List on Tuesday at the request of the council for the petitioner. Yes, in the fresh matters. Next.
Number 4, HVK Murthy, AS Party, Miyaji.
Let's kindly pass on, let's.
Then matter,
last time, day before yesterday, matter was heard.
Where is he?
He's in his legs in quotal number 2, my lords.
Pass over customer.
Number 5, Ravi
Tuesday.
Hegde.
Tuesday
May I
fresh
request it on Wednesday, my lords?
Wednesday fresh.
Great.
Bangalore ಹೋಗ್ಬೇಕಾ?
Number 5, Ravi Hegde, BS Kampe.
Lord, in this case, my lord,
Lord,
the dispute is
the
between
grievance.
my lord, two wives, my lord, of the deceased my lord, employee.
First son given.
Lord, son of my lord, one wife, my lord, has been given my lord, compassionate appointment, my lord. The dispute is between two wives of a deceased my lord, employee, my lord, of JESCOM. Lord, son of one employee has been given my lord, appointment on compassionate grounds. Lord, the
ಇವ್ರದ್ದೇನು?
remaining dispute is my lord, the pension, my lord, actually. There was a P&SC my lord, filed between both the parties, my lord, both the wives.
What happened to that?
They got it compromised. And again, another my lord, P&SC filed my lord, by the first wife, recalling that order. My lord, that is going on my lord, before the my lord, court, the civil court. So
ಈಗ
therefore, my lord,
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ pension?
Pension, my lord, according to the settlement which was entered into.
ಈಗ ಇನ್ನೊಂದು settlement ಆಗಿದೆ ಅಲ್ವಾ? Recalled that order. Where is the settlement?
My lord, there are two settlements, my lord, I will point out. Annexure C is the first, my lord, in P&SC, page 22, where both are parties. Then at the same time, my lord, there was also one more suit set up by respondent, claiming to be wife. In that also, my lord, similar terms.
Claiming to be wife.
ಹೌದು,
First settlement ಯಾರ ಜೊತೆ ಮಾಡ್ಕೊಂಡ್ರೆ?
ಅವ್ರ ಜೊತೆನೆ.
ಮತ್ತೆ claim ಎಲ್ಲಿ ಬಂತು? Yes.
ಆಮೇಲೆ ಅವ್ರೊಂದು ಸೂಟು ಹಾಕಿದ್ರು, ಅನೆಕ್ಷರ್ ಎಫ್.
Recall ಆಗಿರೋದು ಯಾವ್ದು?
Recall ಆಗಿಲ್ಲ. She files, my lord, one more P&SC in P&SC. I have also produced, my lord, at annexure L. That cannot be entertained at all, my lord, by the court. That is what. Yes. In the meantime, my lord, they have, as per the agreed terms,
appointment ಯಾರ ಮಗನ?
appointment ನನಗೆ ಕೊಡಬೇಕು ಅಂತ agreement ಆಗಿದ್ದು. Now they have given it to the, my lord, son of the other wife.
Why?
He's not a party to compromise.
son of first wife was given my lord,
Annexure.
appointment.
No, you have acted in terms of the compromise.
Yes. Lord, he was not a party to the my lord, compromise.
Who was not a party?
Lord, son was not a
Mother
party.
was a
to the
party.
compromise. Mother was
Did
a
you
party.
play these things
Lord,
with
C
these
filed,
people?
Lord, I understand.
And
Lord,
generate litigation. Something
Lord,
you
that
do
is-
and generate litigation.
The problem is not the litigations, Lord, again and again, Lord, they are raising
That's a different
litigations.
thing. There is, when was the appointment given?
Lord, 2014 actually.
Oh, on that date, what was the compromise? The public employment is bartered away like this, can't help, but.
Of course, Lord.
Date ಇಲ್ಲ ನಮ್ಮ ಕಡೆ. Timber ಇದೆ, date ಇಲ್ಲ.
Yes, Ravi.
In 2010, my lord, kindly take annexure H.
First compromise ಯಾವತ್ತು ಹೇಳಿ?
First compromise was, my lord, that was on 29/2008.
In terms of that, what was it?
In terms of that, my lord, I am entitled, the present petitioner is entitled for compassionate appointment.
All right. When was the compassionate appointment given to the son?
My lord, it was given on
17/10/2011. 17/10.
14th February 2012.
ಅವಾಗ ಯಾವ ಕಾಂಪ್ರಮೈಸ್ ಇತ್ತು? ಇದೇನಾ?
ಅವಾಗ ಎರಡು ಕಾಂಪ್ರಮೈಸ್ ಇತ್ತು. ಸೂಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು P&SC.
ಎರಡನೇದು ಯಾವುದು?
ಎರಡನೇದು my lord, annexure F in OS 68/2000.
Date ಹೇಳಿ ಸರ್.
Date is, my lord, 8/10/2008.
First is 29/2010. Next
30/8/2008. ಎರಡು.
ಅದಲ್ಲ. Some confusion is there.
ಓದ್ಕೊಂಡ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
ಇದರಲ್ಲಿ ಇದೆ. First compromise, annexure C is the, my lord, first compromise.
I am asking dates, not your annexure.
20/9/2008 ಅದು P&SC ಆಗಿರೋದು.
20/9/2008. ಅದರ ಪ್ರಕಾರ ಏನು?
ಅದ್ರ ಪ್ರಕಾರ ನಮಗೆ ಕಂಪಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್, ಆಮೇಲೆ ಅದು ಕೊಡೋವರೆಗೆ ಇಬ್ಬರಿಗೂ ಅರ್ಧ ಪೆನ್ಷನ್.
ಆಮೇಲೆ 20th September 2010 ಏನು?
ಸೇಮ್ ಟರ್ಮ್ಸ್.
ಸೇಮ್ ಕಂಪಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
ಸೇಮ್ ಟರ್ಮ್ಸ್.
ಥರ್ಡ್ ಏನು?
ಅದು ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್, my lord, one more P&SC. The earlier compromise was not correct and etc. My lord, they have alleged. That is pending.
That is still pending.
That is still pending. P&SC 11/2012.
Yes, sir.
They did not challenge any of them.
Why do you generate litigation like this? ಅವ್ರಿಗೆ ಯಾಕೆ ಕೊಟ್ರಿ?
Second one is 2011.
But second one is 2011. Second one is 2011. PNDC 14 was 2011.
Where is that order?
Annexure
J1.
Page ಹೇಳಿ.
Page number 39.
correct. Date correct ಇದೆ.
28 sir.
Till the petition number 1 gets appointment and compassion due to health of the person undertakes. Petition number 1 ಯಾರು?
Present petitioner.
ಅಲ್ಲ, this is PNDC 14 of 2011 ಯಾವುದು?
Petitioner B Radha.
B Radha, he is a petitioner.
ಯಾವುದು? ಅದ್ಯಾಕೆ ಹೇಳಿಲ್ಲ? ನೀವು ಹೇಳಿದ ಎರಡು ಡೇಟ್ ಅಲ್ಲೂ ಇಲ್ಲ ಇದು. You said 29/2008 ಒಂದು, 29/2010 ಒಂದು. ಇದು ಯಾವುದು? 14 of 2011.
That is in PNDC 14.
Those are also in PNDC only.
PNDC only.
Which is the third PNDC?
That is PNDC 11/12. 11/12.
Pending ಇದೆಯಾ? ಅದು ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
Pending ಇರೋದು ನೋಡ, that is
Now renumbered as 10 of 21. It is posted on March 3rd.
10/21.
ಇದ್ರ ಪ್ರಕಾರ ಯಾರು ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
That shows Lord, I think Lord, the
Pension or
son Lord,
both. ಎರಡು ಅಕ್ಕಿಗೆ.
Appointment to the son of Lord present petitioner. According to this section, Lord, earlier settlement. So that is
you have made him a party?
Yes, I have made him a party, my lord.
ಮಾಡಿದ್ದಾರೆ.
I have made him a party.
He is made a party.
Who appears?
Mr. Pandu
Present appoint in a party ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ sir.
And your
Who is the, my lord, fourth respondent in the present petition?
Who represents?
Mr. Pandu.
Mr. Pandu, someone Pandu.
Heard the learned counsel appearing for the petitioner. Two wives of an employee of the HESCOM who died in harness are in a squabble with regard to his terminal benefits and entitlement to compassionate appointment. Two deeds of compromise resulted in two orders before the concerned court on 20th September 2008 and 20th September 2010. There is no variation in those orders insofar as the grant of compassionate appointment to the present petitioner is concerned. However, the HESCOM ಏನಿದೆ?
JESCOM.
The JESCOM appears to have played the mischief by deviating from the compromise and granting appointment on compassionate grounds to whom there was no indication in the compromise. Therefore, the petitioner is before this court in the subject petition. The learned counsel, BS, there is no representation on behalf of the fourth respondent. Counsels for the respondent 2 and 3 to explain as to how they could deviate from the compromise when everything else is acted upon in terms of the compromise. So entered into between the warring wives of the deceased employee. List on 21st. Awaiting the appearance of the fourth respondent. Next.
Plus.
Question number 6.
Appearance of R1 and R4.
Arvind D. Kulkarni.
Going for the petition. The post of health educator.
Post of?
Health educator, earlier it is nomenclature as health educator as per the MCA regulations. In 2005, it has been redesignated as health educator cum lecturer, coming within the ACT pay scale. The respondent KIMS institution has notified the post of health educator. Accordingly, the petitioner,
Page.
sorry,
Notification page.
notification I have not placed. I placed.
I have placed it along.
Yes, please.
That's in on 7/2/2024.
R7 euros.
My lords may kindly see. Page
There is
number
R7. ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ?
Let's, I have filed, along with the memo, I have produced certain documents.
Objections ಎಲ್ಲಿ?
Objections in all the 3 petitions I have filed.
ಯಾವ್ದಾರು ಕೊಡಿ, ಯಾವ್ದ್ರಲ್ಲ
ಅಲ್ಲ,
ಹಾಕಿರೋದು?
ಇದರಲ್ಲಿ
The Lordship take 7/2/2024 ಅಲ್ಲಿ certain documents have been placed. 7/2/2024.
Along with the memo.
Along
I
with
have
the memo.
placed it on record on 7/2/2024.
Is it memo with documents or objections?
Memo with the
Are
documents.
separately filed. This is memo.
ಏನ್ ಹೇಳಿ?
Please,
Notification ಎಲ್ಲಿದೆ?
please, not kindly see page 2.
Annexure ಎಲ್ಲಿ is it?
If your Lordship got it, the memo in the first document in the
First
memo.
notification is appointment.
Notification
ಹಾಕ್ಬೇಕಾದ್ರೆ appointment challenge ಮಾಡ್ಬೇಕಾದ್ರೆ notification ತಾನೆ ಅದು promotion
12th April 2010.
Where is, why have you not produced?
No, that they have produced.
Why have you not produced?
Because this is the notification.
Which one?
12th April 2010. Page number 2. Walk-in interview, Lordship 5/4/2000.
5/4/2010.
In
Health-
that,
Health educator.
health educator.
Yes.
In pursuance to that, the petitioner having participated in the selection process appointed as per annexure C.
Appointed when?
Appointed on 24/2010.
All right.
The nomenclature for health educator
Appointed on
24/2010
as what?
as health educator only.
All right.
Whereas the post of health educator as per the MCA regulations, it has been redesignated as health educator cum lecturer
When?
in 2005 itself. Nevertheless, in the notification, they have notified wrongly as health educator.
Health educator come / lecturer.
Lecturer.
All right.
Accordingly, after my appointment, I made a requisition to redesignate me in the post of health educator cum lecturer in tune with the MCA regulation.
Yes.
Considering my request, as per annexure D, a resolution is passed, page 58. Lordship, my writ petition is 10/4876.
Which subject?
In the health educator only. Health educator.
Resolution ಯಾವ subject, sir?
Your Lordship, your Lordship kindly come to page 58 for a moment.
I am at 58.
ವಿಷಯ ಸೂಚಿ 18 ಅಂತಿದೆ. ಶ್ರೀ ಮಂಜುನಾಥ್ ನಡವಲ್ಮನಿ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಇವರಿಗೆ ನೀಡುತ್ತಿರುವ ರಾಜ್ಯ ಸರ್ಕಾರ ವೇತನ ಶ್ರೇಣಿ ಅನುಗುಣವಾಗಿ ಎಸಿಟಿ ವೇತನ ಶ್ರೇಣಿ ನಿಗದಿಪಡಿಸುವ ಬಗ್ಗೆ. ಸದರಿಯವರು ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಹುದ್ದೆಗೆ 20/4/2010 ನೇಮಕಾತಿ ಹೊಂದಿರುತ್ತಾರೆ. ಇವರು ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ ಸ್ನಾತಕೋತ್ತರ ಪದವಿಯನ್ನು ಹೊಂದಿರುತ್ತಾರೆ. 15/3/2005 ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಇಂಡಿಯಾ ಅಧಿಸೂಚನೆ ಅನ್ವಯ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಹುದ್ದೆಯು ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಕಮ್ ಲೆಕ್ಚರರ್ ಎಂದು ಮರು ಪದನಾಮಕರಣಗೊಂಡಿರುವುದರಿಂದ ಅದೇ ರೀತಿ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ಹುದ್ದೆಯು ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ಕಮ್ ಲೆಕ್ಚರರ್ ಎಂದು ಮರು ಪದನಾಮಕರಣಗೊಂಡಿರುತ್ತದೆ. ಕಿಮ್ಸ್ ಸಂಸ್ಥೆ ಮೇಲೆ ವಿವರಿಸಿದ 2 ಹುದ್ದೆಗಳಿಗೆ P&M SM ವಿಭಾಗದಲ್ಲಿ ಮಂಜೂರಾತಿ ಇದ್ದು, ಇವುಗಳ ಪೈಕಿ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ಹುದ್ದೆಯು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಯೊಂದಿಗೆ ಸದರಿ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಿದ ಸ್ನಾತಕೋತ್ತರ ಪದವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಷಿಯನ್ ಕಮ್ ಲೆಕ್ಚರರ್ ಎಂಬ ಹುದ್ದೆಯನ್ನು ಮರು ಪದನಾಮಕರಿಸಿಗೊಳಿಸಿ ಇವರಿಗೆ 2011ರಿಂದ ಜಾರಿಗೊಳ್ಳುವಂತೆ ಎಸಿಟಿ ವೇತನವನ್ನು ನಿಗದಿಪಡಿಸಿ ಬಟವಾಡೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಶ್ರೀ ಮಂಜುನಾಥ್ ನಡವಮನಿ ತಮ್ಮ ಮನವಿ ಪತ್ರದಲ್ಲಿ ತಾವು ಹೊಂದಿರುವ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಹುದ್ದೆಯನ್ನು MCA ಅಧಿಸೂಚನೆ ಅನ್ವಯ ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ಕಮ್ ಲೆಕ್ಚರರ್ ಅಂತ ಮರು ಪದನಾಮಕರಣಗೊಳಿಸಲು ಎಸಿಟಿ ವೇತನ ಶ್ರೇಣಿ ಪಡೆಯಲು ಎಲ್ಲಾ ಅರ್ಹತೆಯನ್ನು ಹೊಂದಿದ್ದು, ತಮಗೂ ಸಹ ಎಸಿಟಿ ವೇತನ ಶ್ರೇಣಿ ನಿಗದಿಪಡಿಸಿ ಆದೇಶಿಸಲು ವಿನಂತಿಸುತ್ತಾರೆ. ಸದರಿ ವಿಷಯವನ್ನು ಆಡಳಿತ ಮಂಡಳಿ ಅವಗಣನೆಗೆ ಹಾಗೂ ಸೂಕ್ತ ತೀರ್ಮಾನಕ್ಕಾಗಿ ಮಂಡಿಸಿದೆ. ನಿರ್ಣಯ: ಸಭೆಯಲ್ಲಿ ಈ ವಿಷಯವನ್ನು ಸಮಗ್ರವಾಗಿ ಚರ್ಚಿಸಿ ಎಸಿಟಿ ಈ ವೇತನ ಶ್ರೇಣಿಯ ನಿಗದಿಪಡಿಸಿದ ಮಂಜೂರಾತಿ ನೀಡುವ ಪ್ರಕ್ರಿಯೆ ಕುರಿತು ಸಮಿತಿ ಅನುಮೋದನೆಯಂತೆ ಇನ್ನಿತರ ಯಾವುದೇ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯಲ್ಲಿ ಈ ರೀತಿ ನಿಗದಿಪಡಿಸಲಾದ ಸೂಕ್ತ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ವಿವರವಾದ ಕಡತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಅಲಾಂಗ್ ವಿತ್ ದಿಸ್ ರೆಕಮೆಂಡೇಶನ್ ಇಸ್ ಮೇಡ್ ಟು ದ ಗವರ್ಮೆಂಟ್. Government as per annexure F, page 69, without any reasons they have rejected.
ತಿರಸ್ಕರಿಸಿದೆ.
This has been subject matter before one of the writ petition.
Which one?
First petition.
First petition.
102239.
102239 of 2008.
102239.
All right.
During the pendency of this writ petition, the respondent institute, considering my request, they have accorded me AICT pay scale as per Annexure EH, page 77, dated 17/6/2019. Page 77, Your Lordship. ಮೇಲ್ಕಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದ ದಿನಾಂಕ 1/6/2019 ಮಾನ್ಯ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ಆರೋಗ್ಯ ಕುಟುಂಬ ಕಲ್ಯಾಣ
What
ಇಲಾಖೆ.
basis was it granted? On the basis of the resolution?
On the basis of recommendation made by the DPC committee. ವಿಷಯ ಅಂತಿದೆ ನೋಡಿ ಲಾರ್ಡ್ಶಿಪ್. 1/6/2019 ಕಿಮ್ ಸಂಸ್ಥೆ
ಇದನ್ನ ಗವರ್ಮೆಂಟ್ ಕಳಿಸಿದ್ರ ಆಮೇಲೆ?
ಇದನ್ನ ಕಳಿಸಲಿಲ್ಲ. There afterwards, as per Annexure J, in order to ratify these promotions, with regard to 150 officials working in the KIMS, they approved retrospectively.
Who approved?
The GC has approved.
All right.
Only insofar as the petitioner is concerned, Your Lordship kindly take page 85. It's Annexure J starts from 78. The list of the promotees have been notified therein, including the petitioner. Whereas in 85, only for the petitioner, they say that it will be placed before the finance department, approval from the finance department. Idadmele, as per Annexure M, they have withdrawn the Annexure N, page 92. They have withdrawn the resolution which they have placed for the FC. They have not withdrawn the promotion which have been effected. As
so, based upon first is nomenclature change, erroneous notification by the institute quoting it only as health
education instead of.
Then resolution saying that yes, AICT pay scale should be granted in terms of the nomenclature that was already there. After that, promotion being granted. Promotion
after resolution,
granted, pay scale fixed.
After resolution, they recommended to the government. Government rejected.
Government rejected. By even otherwise, you are granted.
They have been promoted with effect from 17/6/2019, as per Annexure H.
Once government rejected, then how did they again take it up?
No, Lordship, insofar as the promotion aspect is considered, it is not under the ambit of the government. It is
finance only.
It is neither, because even after promotion also, when they have ratified,
why did they send it to the
no, that is the each of the matter. I don't know. Only for the petitioner, there is no question of sending to the finance department insofar as promotion is concerned. The approval of finance department is not required. It is only a redesignation.
In bylaws, power to give directions. Huh?
Please, no. My submission is not the memo which initially we brought it to the court on 7/2/2024. Lots may kindly see 7/2/2024's memo. Along with that, we have placed the publication as well as the walk-in interview document. May I request, page number 2. My lots got it.
So there,
page number 2 is the walk-in interview. Immediately after the tabular column, next to that is ancillary posts. Ancillary posts. These are not teaching posts at all.
Audiologist, health educator.
Health educator is
physiotherapist, medical record technicians.
Please.
All right.
This is the second post wherein the petitioner had applied. He came to the interview and he was selected as a health educator only. And the appointment order is also, may kindly see page in petition number 102239 of 2018. Page number, Annexure B, page number 17. On 20th/4/2010. It is health educator only. And this is because of the fact.
What is the qualification?
Before this, earlier, before it became autonomous body, before that, there was a post by health educator. That a person was working with in that post. It was a state government pay scale. He retired. Subsequent to his retirement, he was the present petitioner was appointed. May kindly see the same memo which I have placed on record, where in page number 5 it commences insofar as the Medical Council of India's resolution, medical guidelines. The relevant portion would be page number 24. This comes under community medicine. It is not correct to say that it was health educator come lecturer. Let's got page number 24.
Yes.
Department of Community Medicine. Thereafter, it is staff of rural training healthcare. In that, serial number 6. And insofar as urban training health center is concerned, serial number 6. It's health educator only. And the nomenclature itself depicts that health educate. His duty
All right,
is
that's
to
all right.
educate. Yes, please. This is pursuant to. This is the notification passed in the year 2009. He was appointed in the year 2010. With this background.
So what is the equivalence that MCA is granted is referring to?
That the resolution, the regulations that is being projected.
2005. It is here.
NMC or
It is sir.
Please, my lord.
Is health educator equivalent to a lecturer in the MCI?
No.
Lord, I am handicapped by a certain not having the paper.
There is a notification of 16th March 2005, which somewhere projects that health educator and lecturer.
It is an MCI. It is an MCI document, my lord.
MCI, yes. 16th March 2005. Copy ಕೊಟ್ಟಿಲ್ವಾ ಅವ್ರಿಗೆ MCI?
Because in pursuance to the direction of the Honorable Court, we included in copies also. To that extent, the clarification has been sought.
I don't know. Now the MCA has to say health educator come lecturer, provided the Department of Community Medicine shall also have health educator come lecturer. This is not grant of equivalence to the post of health educator. It is the requirement in a community medicine department of a particular hospital.
That is a teaching post.
There should be 3 people. This is statistician come lecturer, epidemiologist come lecturer, health educator come lecturer. Those are teaching posts. Are you doing teaching job?
Yes.
Where in
the very same institute. There is no dispute on that aspect. They themselves recommended for the government doing that.
This is the crux
because your lordship, earlier it is statistics. Now, by virtue of this notification, statistician come lecturers in place. He has been extended ASVT pay scale. That I have already placed with along with the documents.
One more submission.
Epidemiologist is also the similar thing.
In WP number 104876 of 2021, I have filed objections. There is state government has passed yet another order rejecting the very same request. Thereafter, the consequential orders have been passed. R4 may kindly be seen.
Now, what is the consequential order passed against you now?
Now, the promotion which is given effect from 2019, that is 17/6/2019, that has been withdrawn now. Even in spite of the fact that the stay is granted. Stay is granted for the withdrawal of the resolution. Prior to the resolution, they already have given effect the promotion.
Promotion withdraw ಮಾಡಿದ್ದಾರೆ.
Promotion ಈ withdraw ಮಾಡಿರೋದು. And salaries, they said having extended the salary, they are withdrawing the salary from
page number 39.
Recovery ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Recovery ಮಾಡಬೇಕಂತ order ಇತ್ತು. There is an interim order operating in that case.
In spite of interim order, they have recovering.
Recovering.
ಹೌದು. That is my instruction. Recovery ಮಾಡಿದ್ದೀವಿ.
Salary recover ಮಾಡ್ತಿದ್ದಾರೆ.
ಹೌದು. That is my submission.
I'll
ಮಾಡಿದ್ದಾರೆ.
In that case,
ಮಾಡ್ತಿದ್ದಾರೆ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. 7 months
contempt ಹಾಕ್ಲಿಲ್ವಾ?
ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ವಿ. ಆಮೇಲೆ ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಡೈರೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ವಿ.
Contempt was dropped. It is not correct to say that direction to be taken.
Illi alla to make an application before the Honorable Court, IA for direction is also filed.
IA has been ordered to be considered along with the main matter. Lords may kindly see annexure R4 page number 39.
R4
filed along in the objections filed in WP number 104876 of 21.
ಒಂದು WP ಇಟ್ಕೊಂಡ್ಬಿಡಿ. ಎಲ್ಲ
ಬೇರೆ ಇರೋದ್ರಿಂದ ಹಂಗಾಗಿ.
ಇಲ್ಲ, the main writ petition will be one.
The way submissions are made, we can't dispose any case.
4876 will be the in this.
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್
ಇದ್ರಲ್ಲಿ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಕಂಪೈಲೇಷನ್ ಹಾಕಿ.
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಂಪೈಲೇಷನ್ ಇದೆ.
haphazard, nothing is going to happen.
In this writ petition which I am mentioning, because this is the last writ petition which is it comprises of every aspects.
ಇದ್ರಲ್ಲಿ ಎಲ್ಲ ಇದೆ. Don't touch any other petition.
ಇಲ್ಲ ಯಾವುದು. Except the notification.
You
except
take
the
that part.
notification in which they have we have not placed. In all other aspects, this take entire petition.
Yes.
Page number 39, annexure R4.
ಇದರಲ್ಲಿ objection ಹಾಕಿದ್ದೀರಾ?
All the three petitions we have filed.
I am asking in which.
Please, it is filed. 104876.
Annexure?
Annexure R4, page number 39. The state government has passed one more order on 6/9/2021. Even as on today, this order is not challenged.
What order is that?
It is not an order, it's communication.
One second.
ಆಯ್ತು, communication. ಏನಿದು?
Please.
ಇವ್ರಿಗೆ communicate ಮಾಡಿರೋದ?
ನಮಗೆ communication.
ನಿಮ್ಗಲ್ಲ, ಇವ್ರಿಗ?
ಇಲ್ಲ, ಅವ್ರಿಗೆ.
ನಮಗೆ ಕಳಿಸಿ.
ನಿಮಗ್ ಮಾಡಿರೋದು?
ಹೌದು. We had sent proposal to the state government. Lords may kindly see the
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ಇವ್ರಿಗೆ communicate ಮಾಡಿ.
My lords.
ಇವ್ರಿಗೆ ಮಾಡಿದ್ದೀರಾ communicate?
This is placed on record.
By whom? By you?
By the respondent.
Then you are telling he is not challenged. How can he challenge if you don't communicate it?
Whether it is communicated or not, this was placed on record.
Copy to ant ilve illa.
This I have to verify.
University sends it to you and you effect some problem with this, then it will be violation.
I'll place it on. I'll verify.
But lecturer equivalent ashte, that boils down to that.
Centers around whether it is a teaching post or not the teaching post. It is
But
not.
if I have the benefit of the,
Yes, sir.
my lord, while I am not saying that my learned friend has not given me the papers, but if my learned friend may be kind enough to give me the papers, I will take care of it. Mr. Vijay Sharthi is anyway.
See, now it all, if MCI says yes, it is health educator come lecturers, then solves every issue.
Yes.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ. ಇದಕ್ಕೆ ಇದೆಲ್ಲ ಮುಂಚೆ ಮಾಡಿದವರು waste of time.
ಕೊಟ್ಟಿಲ್ಲ. My colleague says.
We'll ಕೆಟ್ಟಿ ಅವ್ರಿಗೆ.
ಇನ್ನೊಂದ್ಸಲ ಕೊಡ್ತೀನಿ.
Bless the matter on Wednesday.
ಒಂದು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಸಪ್ಪ.
ಅಭಿನಂದನ್ ಹಿರೇಮಠ್.
And ಆಮೇಲೆ ಅವ್ರಿಗೆ ಒಂದು dates and events.
Dates of events.
ಹಳೆ ಮ್ಯಾಟೀರಿಯಲ್ ಹಾಕ್ದೆ ಎಲ್ಲ 4 ಪೆಟಿಷನ್ ಇರುತ್ತೆ, you back and forth you go on.
Synopsis ಮಾಡ್ಕೊಡು.
Yes. Next.
Yes, Manoj. This is a matter in respect of the workman which was there. Yes. So I will seek with the liberty to go to the labor court and with the directions permitting me to go
6 months
there.
I will direct completion.
Yes.
5 years ಆಯ್ತು sir.
Other than wrongfully.
ಒಂದು 13 years ಆದ್ಮೇಲೆ ಕಳಿಸಿದೆ. ಏನ ಕ್ಲರ್ಕ್ 2009 pending.
Yes.
Objections are filed long ago that it is not maintainable here. The petitioner is before this court calling in question an order dated 26/8/2019 by which as a measure of penalty the petitioner is dismissed from service. The petitioner is in the cadre of a clerk. This is an undisputed fact, and is a workman as obtaining under the Industrial Disputes Act. If the petitioner has to call in question the order of dismissal against him, it is the appropriate forum would be
Compulsory retirement.
Anything compulsory retirement, dismissal compulsory retirement. The appropriate forum would be the industrial tribunal by raising an appropriate dispute or seeking a reference from the hands of the government of India. In that light, I deem it appropriate to dispose the petition, reserving liberty to the petitioner to avail of the remedy of raising a dispute before the appropriate industrial tribunal. Since the dismissal is of the year 2014, in the event the dispute is preferred before the appropriate industrial tribunal, I deem it appropriate to direct the tribunal to conclude the dispute within an outer limit of 6 months in accordance with law. All contentions that are urged before this court, the petitioner would be at liberty to urge them, the parties would be at liberty to urge them before the concerned court.
In fact, he has not challenged the order L. Annexure L is a compulsory retirement. That itself is not.
ಇಲ್ಲಿ ಏನು ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಚಾಲೆಂಜಿಂಗ್. Yes. Ordered accordingly.
FP Patil, C. Jagdish, Shivraj.
Milords, this matter, Milords, where the caste certificate of the petitioner, Milords.
Lord, may I submit to
Jagdish sir.
Lord, the CRSL has not conducted inquiry as contemplated under my Lord the Kumari Madhuri party. Your Lordship may set aside and direct the DCVC to refer the matter to the CRSL purely to conduct an inquiry as per the law laid down by the
No,
Kumari
I will.
Madhuri
I
party.
will. ಯಾಕೆ
ಅಲ್ಲ
ಮೇಡಮ್?
ಸ್ವಾಮಿ, ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸುಣಗಾರ ಅಂತಿದೆ, ಬ್ರದರ್ ಸುಣಗಾರ. ಹೌ ಕ್ಯಾನ್ ದೇರ್ ಕುಡ್ ಬಿ ಟೂ ಡಿಫರೆಂಟ್?
ಅಲ್ಲ, ಲೆಟ್ ದಿ DCVC
ಅಲ್ಲ, DCVC ಗೆ ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ,
There is a report of the fact-finding authority, Milords, that this petitioner belongs to Bhovi caste. Contrary to that finding, Milords, the DCVC, Milords, records finding that that has been returned, Milords.
circumstance, right?
That has come up, Milords, for the first time in the before the Appellate authority. Before the DCVC, Milords, no such finding was there, Milords. And Milords, the Panchayat Dast, Milords, has been produced at Annexure J. That also, Milords, records that this and
We will set this aside and send it back to verify everything and then pass necessary orders.
this
Sir,
is
I
a
can't scrutinize this.
this is a third round, Milords.
Anyway, problem ಏನಾಗಿದೆ ಕೆಲಸ ಇಲ್ಲ.
He is, Milords, he is working as a grade 2 attender, Milords, in
We will be
KPTCL.
continuing as long as these proceedings are pending. Yes.
Milords,
Sunagar Bhovi category 1, is it? You are a Sunagar.
no, Milords, Bhovi community, Milords. That is a finding recorded, Milords, contrary to the.
Which is page, madam?
Please.
ಅಲ್ಲ 39th ತಾವು ನೋಡಿದ್ರೆ,
The order of the respondent number 2, Milords, is at Annexure L, Milords. And the order of the respondent number 1 authority, Milords, Annexure M, Milords. The report of the Tahsildar, which was addressed to the Deputy Social Welfare Department, Annexure K, Milords. Page 48.
Yes, Jagdish sir. There are so many documents in favor of the petitioner.
No. With due respect, my lord, kindly turn to ink page 30.
Unmute ಮಾಡಿ.
ಅನ್ಮ್ಯೂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಪೇಜ್ 39 ತಾವು ನೋಡಿ. Am I audible, my lord?
Proceedings will not go on like this.
And Annexure C, D, and E, Milords, are the caste certificate of the brother also. Please, Milords.
Number 9. Yeah, Kurmari.
Your Lordship. In this matter, Your Lordship has directed me to
Mic ತೊಗೊಳ್ಳಿ madam. ನೀವು ಒಂದು mic ಇಟ್ಕೊಂಡ್ಬಿಡಿ permanent.
file an affidavit, Your Lordship, of CDPO about the residential inquiry.
ಕನ್ವಾಡಿ.
Yes, Your Lordship.
ಏನಿದೆ?
She is from that village only, Your Lordship.
Who?
The respondent number 4, Your Lordship.
The appointee.
Please, Your Lordship. But the petitioners are submitting, Your Lordship, that she is from, the respondent is from ward number 1, not from ward number 2, Your Lordship. But the notification says, Your Lordship, for, may I take Your Lordship to
ಸಂಬಂಧಿಸಿದ
page?
ಅಂಗನವಾಡಿ ಕೇಂದ್ರದ ಗ್ರಾಮಾಂತರ ಪ್ರದೇಶ ಕಂದಾಯ ಗ್ರಾಮ ಹಾಗೂ ನಗರ ಪ್ರದೇಶ ಕಂದಾಯ ವಾರ್ಡ್ಗಳನ್ನು ಪರಿಗಣಿಸಬೇಕು.
Please, Your Lordship, page number 8, Your Lordship.
ಅಲ್ಲೇ
Point number 5, Your Lordship.
ಅದೇ ಓದಿದ್ದೀಗ.
ಅದೇ ಕಂದಾಯ ಗ್ರಾಮ, Your Lordship, ರೆವಿನ್ಯೂ ವಿಲೇಜ್, Your Lordship, ನಗರಗಳಿಗೆ ವಾರ್ಡ್ಗಳನ್ನು ಗ್ರಾಮ ಹಾಗೂ ನಗರ ಪ್ರದೇಶಗಳಿಗೆ ಕಂದಾಯ ವಾರ್ಡ್ಗಳನ್ನು.
Petitioner is before this court calling in question. ಇಲ್ವಲ್ಲ petitioner ಯಾರು ಮೇಡಮ್? ಮುಂಚೆನೂ ಬಂದಿಲ್ವಾ? ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
ಪ್ಲೀಸ್.
petitioner ಏನಾಗಲ್ಲ ಬಿಡಿ ನೋಡಿ.
Number 10. Sunil S. Desai, MS Hirima.
List on 3rd.
This is PhD last date, Lord. They took cancellation, the ground that attendance.
Where is he? Adhe, the guide has created the problem.
Yes, guide.
Sorry, Williams.
Close
May I
it.
request on Wednesday, Lords? Illa, we have communicated. Adu last occasion, Lordships.
ಅವರೇ ಕರೆಕ್ಟ್ ಮಾಡ್ತಾರಾ?
Wednesday, by Wednesday, I'll put
If they are
before.
setting right the anomaly, no problem. Otherwise, we'll pass orders.
We have communicated, my lords. They have said that by Wednesday they'll inform us. That is, if
Inform
not by
us.
Wednesday.
Monday, Tuesday, badala.
Uh,
Wednesday.
Thursday.
Hey,
Adnan.
Wednesday. Yes.
Yes.
Fresh matters.
Please.
Next.
Number 11, Satish MS. By Lakshmi Kant Reddy.
Please.
Under the claim is made by the respondent number 4 under the Senior Citizens Act 2007, claiming maintenance, my lords, as
Who is
against
the respondent number 4?
respondent number 4 is,
Yeah,
my lords,
yeah.
the
Mother,
mother-in-law of
Assistant Commissioner's order.
this Assistant Commissioner order operative portion is at page number 32, Your Lordship. It starts
30?
from 32.
Where
Starts
is
from serial number.
gift enidu?
We have sought, Your Lordship, transfer of the gift, Your Lordship.
Where is gift deed?
Gift deed antandre we says that, Your Lordship, it is transferred to the son property.
How?
Usually orally and by giving the varadi we have transferred.
Ah.
Now their contention, petitioner is the owner of the owner of the property, Your Lordship. On the register sale deed purchased on year 2021.
He is the subsequent purchaser.
Please, he is not son, Your Lordship.
All right.
Subsequent purchaser. Now they say they have made application before the deputy commissioners challenging the assistant commissioner order.
Who has
Saying-
filed?
Please, Your Lordship.
Who has filed?
The owner has filed. Son has not filed. Owner has filed saying that I have purchased the property and I have not heard. That is the only their ground. Now deputy commissioner saying
Now,
that, Your Lordship.
1 minute, madam.
Please.
Fourth respondent is the senior citizen who went before the assistant commissioner. You,
Please.
how many people are here?
yes.
Who is the one who goes before the assistant commissioner?
Before assistant commissioner, my lords, respondent number 4, she has preferred application, making all her daughters and daughter-in-law, grandchildren as a parties, without making the petitioner as a party.
Why?
Claiming maintenance, my lords, under the Senior Citizens Act.
Maintenance.
Yes.
You are not a party there?
No, my lords, I was not a party.
But the order is passed against you.
Yes, there were 6 properties which were mentioned in our application, wherein assistant commissioner passes an order for changing of mutation in respect of my property that is sold by virtue of registered sale deed.
My property in the sense the property.
The property, my lords, purchased by the
Whom
petitioner.
did you buy from?
I bought it from the
Son.
respondents 5 to 9.
Respondents?
5 to 9, my lords.
5 to 9.
Annexure A, my lords, is the registered sale deed.
When was it transferred to respondent 5 to 9 by 4?
4, my lords, she has given Vardi before the for while entry in respect of her name of her son, Wali Basha. Please.
12 to 21.
12 to?
21.
Yes.
So entries are made in favor of these 5 to 9.
Yes.
Yes.
Now it's a subsequent purchaser. So when did you buy it from this 5 to 9?
My lords, on
Immediately after.
12 to 21, my lords, it is entries in respect of my name is concerned. 12 to 21. I bought it on 11 to 21. I have purchased the property on 11 to 21.
All right. When did she go before the assistant commissioner?
My lords, 23 to 2021.
Where is the order of the assistant commissioner?
My lords, on 29/12/2021. Order of the assistant commissioner.
So he directs change in mutation entries?
Yes.
First illegality. Assistant commissioner had no business to change, direct change of mutation entries. And him filing an appeal before the deputy commissioner was not maintainable. Now, you agitate it anywhere you want. You maintain send kodtare. Yaru, neevalla. Who is the 5 to 9 yaru?
Please.
How much are you paying her?
She's not, lords.
You have sold the property to him, made money. You're not taking care of her? So pay 10,000 maintenance.
And assistant commissioner, Your Lordship, in his order also involved the property of one house property that should also return to the mother, for me, as well as including the suit property which they have produced.
He has,
They have
he has
purchased.
no business to pass orders on mutation entries. No,
So only not registered sale deed, only on the Varadi the entries has been changed. Instead of we have challenged under 136(2)
You should
senior
have done
citizen
it there.
act. 136. senior citizen alle kelida.
We'll leave you open for all remedies. Assistant Commissioner ಮುಂದೆ ಈಗ you paying something?
Nothing.
5 to 9, pay something.
Lords,
10,000.
she is residing with me only.
With you?
5 to 9, ಹೌದು.
ಮತ್ತೆ ಹಿಂಗೆ ಕೇಳ್ತಾಳ.
It's all-
ಆಮೇಲೆ instead of one house property, she is claiming at least old age time ಅಲ್ಲಿ ಇರಕ್ ಒಂದ್ ಮನೆ ಇರುತ್ತೆ.
So legally we can close it, but that will not help you at all.
Or else it may
I
be
can't-
remanded,
I
your
can't pass
lordship.
any order in his petition.
We were reminded to the assistant commissioners.
If it is remanded and
Bail of remedy as available in law, even going before the assistant commissioner appropriately. But not, you should implement the one who is in possession of the property.
Yes, that is wrong.
it is not.
We'll close only on that ground.
Yes.
Please. The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The fourth respondent owned certain property. By way of quote unquote varadi, the entries are transferred in the name of respondents 5 to 9. Respondent 5 to 9 execute a sale deed in favor of the present petitioner on 11/2/2021. Pursuant to the sale deed, the entries are changed in favor of the present petitioner qua the subject property. It transpires that the fourth respondent then approaches the assistant commissioner seeking maintenance against the children, against her children and other, against all her children and grandchildren. This comes to be allowed by the assistant commissioner on 29/12/2021 by taking away the right that is accrued to the present petitioner who was not made a party to the proceedings before the concerned court. The petitioner then prefers an appeal before the deputy commissioner. The deputy commissioner also confirms the order passed by the assistant commissioner. Therefore, the petitioner is before this court in the subject petition. The learned counsel submits that the petitioner who was in possession of the property and the fourth respondent being fully aware of the possession of the petitioner of the subject property ought to have made the present petitioner as a party to the proceedings, as rights of the petitioner is taken away by the order of the assistant commissioner. The same is repeated by the deputy commissioner. He would submit in that deputy commissioner and would seek quashment of both the orders. The learned counsel appearing for the respondents would seek to defend the action by contending that the senior citizen fourth respondent who by way of a vardi had transferred to 5 and 9 is today left in the lurch. Be that as it, be those submissions as they are, the issue now revolves around a narrow compass. It is an admitted fact that the fourth respondent approaches the assistant commissioner on 23/2/2021. An order comes to be passed on 29/12/2021, by which the petitioner who had come in possession of the property he would lose the property. ಬರೀ ಎಂಟ್ರೀಸ್ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ರೆ ಕೇಳಿದ್ರಲ್ಲ?
Yes.
ಯಾರೇನು ಓದಿಲ್ಲ ಬಿಡಿ. Yes, also. But the effect of which the will ಏನು ಹೇಳಿದೆ ಮೇಡಮ್ ಕೊನೆಗೆ? Who had come in possession of the property, sir. If the right of the petitioner who was in possession of the property as on the date of the filing of the petition before the assistant commissioner, the petitioner ought to have been made a party to those proceedings. In the light of the order being passed against the present petition, admittedly passed against the petitioner, I deem it up and against the petitioner and him not being a party to the proceedings, the order is in blatant violation of principles of natural justice. Therefore, I deem it appropriate. Therefore, without going into the merit of the claim or the defense of any of the respondents, I deem it appropriate to set aside the orders and remit the matter back to the hands of the assistant commissioner to pass necessary orders in accordance with law after hearing all the parties to the list.
Only insofar as your lordship in survey number 105, their claim is only against 105.
Allala.
Not against two properties.
Allala. Application is for including all 6.
ಅಲ್ಲೇ ಮಾಡ್ಕೊಡಿ.
Yes. There are other 6 properties.
Everything there.
Nitish K. Viraj Kumar.
Lord, appear for the petitioners. Lord, short question is, my Lord, the past service rendered.
As per order of this
Shiraj
court.
Mudada.
Please, please.
Marriage.
Please.
Shiraj Mudada's daughter's marriage. We'll take it on 24th.
Please, oblige.
List on 24th. Yes.
Oblige.
13. Sabil Ahmed. Shikayat
Lord,
number.
For the petitioner,
in the fresh matters list, my Lord,
this case, annexure E,
Password.
annexure E is under challenge, my lords.
45A violation.
Indeed, my lord. 45A violation as well as in violation of section 60 of the Registration Act.
This,
While considering the undervaluation,
no,
the
as the
district registrar has chosen to.
Aswara. Aswara agala. Today's date. Monday. Monday preliminary hearing. Yes.
18th, my lords. May 16th.
18th.
18th.
Oh, correct.
Number 14. CV Angli.
18th beda. Yeah, it's very
Monday, my lords. I'll appear.
Monday is Sankala. Anyway, yes. 18th next.
Fresh matters, in fresh matters.
Preliminary hearing.
My lord, this acquisition of rights under sale deed, my lord, being reported to the prescribed officer under the KLR Act, my lord, he has refused, my lord, only just because that the erstwhile owner had raised certain loan from respondent number 3 cooperative society, and they have objected, my lord. In accordance with section 128 and 129 of KLR Act, my lord, the prescribed officer is.
Yes, my lords. No, sir, endorsement has been issued, saying that, my lords, as there is a, my lords, dispute by my lords, the society which has a lien on that property, my lords. As per section 128, my lords.
Registration madilla anta.
Alla, registration agide.
Sale is registered, my lord.
Sales certificate issue ಮಾಡಿದ್ದಾರೆ.
Two banks had lent loan, my lord. The first mortgagee right holder bank, my lord.
What is the problem now?
Lord, just because respondent number 3 cooperative society, who is a second charge holder on that particular property in respect of a loan raised by the erstwhile owner, my lord, this particular respondent number 2 has refused to enter my legitimate entry of the name into
bracket ಅಲ್ಲಿ ಹಾಕಬೇಕು. Subject ಅಷ್ಟೇ.
ಏನಾಗುತ್ತೆ, the difficulty is there is no problem to enter. Once there is a dispute, under section 129 we have to hold in proceedings. Then name has to be entered.
No, I'm also submitting some decisions.
Register ಆಗಿದೆ.
So on 128 and 129 of KLR Act, my lord, comes page number 1555, my lord, proviso to section 128 onwards of the Karnataka Land Revenue Act imposes a statutory duty on the revenue officer concerned.
Tuesday, fresh matters. Next.
Number 15. Kiran M. Goli.
In investigation report to the submitted in respondent.
Missing complaint.
Yes, my lord.
Missing complaint. The husband is missing on complaint ಕೊಟ್ಟಿದ್ರು. Lords on 1/3/23 from the date, lords, after searching him, the related areas and also the UD cases have been also searched. Missing person not found until on 1/3/23 ಗೆ ಮಾಡಿದ್ದಾರೆ, ಕ್ಲೋಸ್
No,
ಮಾಡಿದ್ದಾರೆ.
my lord. ಮಾಡಿಲ್ಲ. ಇಲ್ಲ. ಅದ್ರದ್ದು ಯಾವುದು ಇಲ್ಲ, my lord. ಆ ರೀತಿ FIR ಆದಿಂದೆ 100 ಸತ್ತನು ಹೋಗಿ ಬಂದಿದ್ದಾರೆ. ಅವ್ರ ತಂದೆಯವರು ಕೂಡ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆದ್ರು. ನೆಕ್ಸ್ಟ್ ಈಗ ಅವ್ರ ಬ್ರದರ್
ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿಲ್ಲ, my lord. ಅದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ ವಿತ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಅಂತ.
ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ.
my lord, 2020 ಮ್ಯಾಟರ್, my lord.
Lords, after holding an investigation.
ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲಾ ಕಡೆ ಅಡ್ಡಾಡಿ.
ಎಲ್ಲಿದೆ ಅಡ್ಡಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ?
ರಿಪೋರ್ಟರ್
ಅಂದ್ರೆ they have lords went to the police stations.
There is a crime registered in 109 of 2020.
Yes.
20.
That is for 363
Missing.
You trace out and what is to be done, you do inquiry and ಮಾಡ್ತಿದ್ದೀರಾ ಅಲ್ಲಿ?
ಅಲ್ಲ, that the procedures have been followed.
Produce the report, whatever report you prepared after investigation. List on 27th.
Please.
Yes.
Number 16. Grievance Hegde. He Hanumarati.
Lord, this is the matter, my lord, to refresh the memory, my lord. The Rajnish versus Neha was not added and
Presently, I am not working, ma'am.
We'll send it back to assets and liability statement alle haki. The petitioner is before this court calling in question an order dated 23/1/2024 passed in criminal miscellaneous 307 of 2022 by which an amount of rupees 7,500 per month is awarded as interim maintenance to be paid by the husband to the wife. The husband is before this court calling in question the said order. Heard so and so. Facts in brief germane are as follows. The petitioner and the respondent get married on 25/2/2021. ಮಕ್ಕಳಿದಾರಾ? ಇಲ್ಲ.
No,
No,
madam.
man.
The relationship between the two flounders, and on floundering of the relationship, several proceedings are instituted by the wife against the husband or the husband against the wife. The issue in the list does not pertain to those proceedings. The petitioner, the respondent wife, files an application before the concerned court invoking section 24 of, invoking section 125. 24 or 125?
125.
125 of the CRPC, seeking maintenance from the hands of the husband. The concerned court, by the impugned order, directs payment of maintenance at rupees 7,500 per month to the petitioner, to the wife by the petitioner. The learned counsel appearing for the petitioner would submit that the wife herself is employed and is not in need of any maintenance. He would above all submit that the filing of assets and liabilities statement before the concerned court is not complied with in terms of the directions of Rajneesh versus Neha. He would submit that assets and liabilities statement should be preferred before the concerned court, and the concerned court should be in a position to assess the same and award maintenance or reject as the case would be. The learned counsel appearing for the respondent wife would admit the fact that the assets and liabilities statement was not placed before the concerned court, and would leave a decision to the court. I have given my source. The aforenarrated facts are not in dispute. The issue lies in a narrow compass as to whether the husband and the wife, prior to the impugned order directing maintenance of 7,500, had placed their respective assets and liabilities before the concerned court.
Lord, wife has filed, my lord, but she has shown false affidavit.
Correct. Concerned court. The wife is said to have filed certain assets and liabilities statement, which according to the learned counsel for the petitioner is completely false.
Yes.
The wife,
She suppressed her.
the wife
again
suppresses the employment that she is in. The learned counsel for the respondent defends the action, contending that she is now not employed and therefore is in need of maintenance. Be those submissions as they are, the non-compliance with the directions of Rajneesh versus Neha would lead to obliteration of the order and a direction to the concerned court to consider the application of the petitioner under section 125 of the CRPC, strictly in consonance with law, after securing the latest assets and liabilities statement from the hands of the petitioner husband and the respondent wife both. The exercise shall conclude within 3 months from the date of receipt of the copy of this order.
It is
In the light of the aforesaid circumstance, the impugned order is set aside. The matter is remitted back to the hands of the concerned court to pass necessary orders, bearing in mind the observations made in the course of the order.
It is already filed and same copies before my lord.
Yes.
Please.
17, Jagdish Patil, MT Bangi.
Petitioner. This is the victim's compensation, your lordship, only on 2 points. 357, your lordship, that A, 4.
ಎಷ್ಟು ಕೋಟಿ ಕೇಳಿದ್ದೀರಾ?
ಅಲ್ಲ, ಏನು ಕೊಟ್ಟೇ ಇಲ್ಲ, ಅದಕ್ಕಾಗಿ ಇಟ್ಸ್ they say that your lordship, the accidents involved ಆದ್ರೆ we are not liable to pay ಅಂತ ಬರೀತಾರೆ. But 357A, your lordship,
ಇನ್ಶೂರೆನ್ಸ್ ಇರಲಿಲ್ವಾ?
ಇನ್ಶೂರೆನ್ಸ್ ಇರಲಿಲ್ಲ ಇವರಿಗೆ, ಅದಕ್ಕಾಗಿ But the offender, when the offender is also that wordings, when the offender could not be traced out. 350 in
matter yesterday.
Yes, sir.
Supreme Court's judgment in Rajshekhar's case was relied on, where roads should be free of accidents, and if there are accidents, the reason for that accident should be the reason for compensation. Illen tondre agide. Il accident ಏನು?
Accident, my lord, it does.
Accident ಆಗಿದ್ದು ಒಪ್ಪಿಕೊಳ್ಳಿ. On the highway, bro.
On the highway.
Reason for the accident.
It is some third person wrote that the unknown vehicle hit and run.
The victim, Lord, was transferred. On the two-wheeler, he was traveling along with his belongings.
Yes, sir.
The eligibility criteria for compensation under the scheme 2011, Your
What
Worship.
scheme is that?
That the scheme has been.
Karnataka victim compensation.
Victim, that's the three.
Accident ko idea. Victim
Accident has been, it is not considered, Your Worship. The
No,
cases.
victim compensation scheme elide.
Scheme, ಅದೇ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ next year EMA kindly in page 30, Your Worship. Next page ನಲ್ಲಿ victim means a person who himself crime, because Your Worship is not that, because immediately they registered the case under the IPC, Your Worship.
ಯಾರಿಗೆ?
ಅಲ್ಲ ಯಾರಾದ್ರೂ offender ಗೆ 279 304 that's Your Worship. It's my
279 338
338 or 304A. Then when it's the offender, next page Your Worship, 357A, next page Your Worship, in page 31, eligibility for compensation, serial number 6, Your Worship, that a victim shall be eligible for the grant of compensation if the offender is not traced or identified, but the victim is identified where no trial takes place, so and so. Such victim may also apply for grant compensation under subsection 4 of section 357A of the Act. In my case, Your Worship, the offender is not traced. Case has been registered. C report has been filed. So the crime has taken place, Your Worship, nobody has disputed it. But by deleting that, we are not entitled when the motor vehicles case is there, Your Worship. That's the only question.
Correct.
No other, Your Worship.
Insurance illa anta ಇದೆ.
Insurance illa, ಅದೇ ಒಂದೇ ಆಗಿದ್ದು.
This is meant for somebody else. Victim as defined under the CRPC.
ನಾನು ಅದಕ್ಕೆ ಅದನ್ನು ಬರೆದಿದ್ದಾರೆ, ಅದು ವಿಕ್ಟಿಮ್ ನಾನು ಓದಿದೆ ಈಗ. ಅಲ್ಲೇ ಇದೆ ಅದರಲ್ಲಿ.
See, these are primarily for rape victims. Victim compensation ಚಾರ್ಟು ಇದೆ ಇಲ್ಲಿ. Not for you. ಇನ್ಶೂರೆನ್ಸ್ ಮಾಡಿಸಿದ ಗಾಡಿ ಓಡಿಸ್ಬಿಟ್ಟು
ಅಲ್ಲ ತಪ್ಪಾಗಿದೆ ಅಂತ
ತಪ್ಪಾಗಿದೆ ಮುಗಿತು, ಏನ್ ಮಾಡಕ. No, if this is, then it will open Pandora's box.
It is gone.
At least for the not present petitioners, in future some should not. ಅದಕ್ಕೆ ಅಷ್ಟೇ ನಮ್ದು.
ಫ್ಯೂಚರ್ ಇನ್ಶೂರೆನ್ಸ್
ಮಾಡ್ಸಲ್ಲ, ನಮ್ದಲ್ಲ ಹೇಳೋದು ಬೇರೆಯವ್ರಿಗೂ, ಯಾಕಂದ್ರೆ
ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಬ್ರೇಕ್ ಇಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಕಷ್ಟ
ಇಲ್ಲ ಅಷ್ಟೇ.
There's one more ground.
Petitioner.
One more ground, my lord, on which the claim is rejected. It is, my lord, filed after 1 year.
ಅದು ಬೇರೆ ಲಿಮಿಟೇಷನ್ ಇದೆಯಾ?
ಲಿಮಿಟೇಷನ್ ಪಾಯಿಂಟ್ ಎಲ್ಲಿದೆ?
Then, my lord, the appeal was filed after a delay of 1 year.
ಅಲ್ಲ, that limitation is controlled. Okay.
Very.
Victim ಗಳ ಲಿಮಿಟೇಷನ್ ಅಂತ ಹಾಕೋಂಗಿಲ್ಲ. ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ I will not answer.
Well, please.
The petitioner is before this court calling in question an order dated 11/10/2022, which rejects the claim for compensation on a road traffic accident under the Karnataka Victim Compensation Scheme 2011. Heard so and so. Facts in brief, germane, are as follows. On 7/12/2018, it transpires that the father of the petitioners dies.
Yes, sir. Subsequently.
Dies in a road traffic accident, succumbing to injuries sustained in the road traffic accident.
On 5/1/2019, he succumbed.
5/1/2019.
He was in a hospital for almost
1 month.
On 7/12/2019, the father of the petitioner meets with a road traffic accident
18.
and gets severely injured. Is said to be
18.
Is said to be in hospital for over a year and later succumbs to the injuries.
1 month.
Sorry, 1 month. Nearing 1 month.
19 ಅಂದ್ರೆ ಮತ್ತೆ
19 ಅಂದ್ರೆ 2018 last 7/12 ಅದು
5/1.
And was hospitalized for over a month and succumbs to the injuries sustained in the road traffic accident. The claim is made by these petitioners, the children of the deceased, invoking the provisions of the scheme before the appropriate authority. The claim comes to be rejected, the rejection of which is challenged by filing an appeal, and the appeal also comes to be rejected. It is these two orders that are called in question before this court by the petition, in the subject petition. Learned counsel Jagdish Patil would submit that the father of the petitioner was driving a vehicle which had no insurance is an admitted fact, but that does not mean his claim to be a victim and grant of victim compensation should be denied under the act. So under the scheme, he would submit that the matter requires reconsideration at the hands of the respondent. The learned counsel Mrityunjay Tata Bangi appearing for ಯಾರಿಗೆ ಬಂಗಿವ್ರೆ?
1 and 2.
Appearing for respondent 1 and 2 would refute the submission contending that cases covered under the Motor Vehicles Act would not be covered under the scheme. This is a case where it is completely covered under the Motor Vehicles Act, and the negligence attributable to the person who was riding the bike, riding the two-wheeler. The learned counsel would submit that if this claim is permitted, then it would open Pandora's box by plethora of claims being registered on cases where insurance had not been taken or insurance had lapsed. I have given my anxious considerations on. Therefore, narrated facts are not in dispute. The claim is under the scheme. The scheme is notified on 22/2/2012. The scheme defines who is a victim. Mark madam. Certain clauses of the scheme becomes germane to be noticed anta madibittu. Clause 2 to 6, then 7.
7 you wrote.
7.
Yes.
The victim. The definition of victim in the aforequoted scheme is unequivocal. A victim would mean himself who has suffered a loss. Victim would mean a person who himself has suffered loss or injury as a result of a crime and would require rehabilitation, and includes his dependents who has suffered loss or injury as a result of crime and would require rehabilitation. The father of the petitioner traveling on a two-wheeler meets in a road traffic accident, and result of the accident is succumbing to the injuries after a month. The father can never be treated as a victim under the scheme. Is the first threshold that the petitioners are unable to cross. The next would be the eligibility for compensation Clause 7(7) clearly mandates that cases covered under the Motor Vehicles Act wherein compensation is to be awarded by the Motor Accident Claims Tribunal shall not be covered under the scheme. The case in the case at hand, it was a case where a claim should have been made before the Motor Accident Claims Tribunal, but unfortunately the rider of the motorcycle was not insured. Therefore, for this circumstance, an interpretation that runs completely counter to the scheme cannot be laid in the case at hand, merely because a crime is registered against someone else, the offender, and the offender would not mean that the father of the petitioner would become a victim.
Father of petition number 1 and 2, husband
Father
of
of petitioner 1 and 2,
and the husband of
third
petition,
petitioner
3.
would become a victim. Finding no merit in the petition stands.
Please.
Bill number 18, Sheridan Patil.
Lordships have directed Milords to deposit 5 lakhs. It was deposited. Another Milords 10 lakhs was deposited in the respondent bank Milords. They had to verify the.
May please, Lordships, I appear for the respondents here.
And Tuesday.
Milords interim order may kindly be.
Interim order subsisting will continue to the next date of hearing.
May I make one submission before this court?
Sir, Kambira.
For the petition, my lord, government has given amnesty scheme, my lord, to avail the benefit. I want to withdraw the writ petition.
Withdraw the petition.
To avail the benefit, liberty to
Vishwasya Vivada.
amnesty schemes and recent amendments.
Petitioner seeks to withdraw the petition, and a memo to the defect is filed. The memo reads as follows: amnesty scheme.
Schemes and recent amendments to avail the benefits.
Disposed as withdrawn in terms of the memo.
And Lordship serial number 135, Lordship
Same,
permission. Same.
135 also. Same.
Please, much.
Please, my lord. The petitioner and the respondent of 5 at the petitioner and the respondent of 5 at the applicant for the tender issued by the respondent number 2, my lord. My application came to be rejected.
9/1/2024. ಒಂದು ವರ್ಷ ಆಗೋಗಿದೆ. What is the tender period?
5 years.
5 years.
5 years.
5 years. My application came to be rejected on the basis that I'm disqualified. I'm not qualified for the.
Why?
My lord, Annexure E, may kindly see, it is the report. On the basis of the report, this order has been issued. Annexure E, page number, my
Who is the
lord.
successful bidder now?
My lord,
Who is the successful tenderer?
respondent number 5, my lord.
Respondent 5. Served.
Served unrepresented.
11th parrot, page number 34, my lord.
20?
Page number 34. 11th parrot, page number 34.
34.
34. Annexure E.
Fishing contract.
ಹೌದು.
ಹೇಳಿ.
My lord, 34, my lord.
ಹ್ಮ್.
ಅದರಲ್ಲಿ 4ನೇ ಲೈನಿಂದ ಹೇಳ್ತಾರೆ, ಸಂಬಂಧಿಸಿದ ಆಡಿಟ್ ವರದಿಗೆ ಅನುಪಾಲನಾ ವರದಿ ಸಲ್ಲಿಸಲು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಸಂಘವು ಹಿಂದಿನ 8 ವರ್ಷಗಳ ಕಾಲ ಯಾವುದೇ ಕೆರೆಗಳನ್ನು ಗುತ್ತಿಗೆ ಪಡೆದಿರುವುದಿಲ್ಲ. ಸಂಘದ my lord,
ನೀವಾ?
ಹೌದು. ಸಂಘದ ಪಾಸ್ಬುಕ್ ನ ಪರಿಶೀಲಿಸಲಾಗಿ ಪಾಸ್ ಪುಸ್ತಕ ಹಾಗೂ ನಗದು ಪುಸ್ತಕಕ್ಕೆ ಯಾವುದೇ ತಾಳೆ ಇರುವುದಿಲ್ಲ.
Yes, government.
My lord, Annexure C is my application.
ಅದರಲ್ಲಿ ಎಲ್ಲ ಹೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ my lord. ಅದರಲ್ಲಿ ಇವ್ರದ್ದು ಹೇಳ್ತಿರೋದು ಅನುಪಾಲನಾ ವರದಿ ಎಲ್ಲ ಕೇಳಿಲ್ಲ ಅವರು ಯಾರು.
Lords, there is already one writ petition was filed, page 9, my lords, by the respondent number 5.
Respondent number 5.
5. ಅದರಲ್ಲಿ notes page 14, para 10. ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟು ಮಾಡಿದ್ರು. ಅದರ ಪ್ರಕಾರ ಮಲಾರ್ಸ್ his tender is ಮಲಾರ್ಸ್ application is rejected and they are the ಮಲಾರ್ಸ್ the respondent number 5.
Objections ಹಾಕಿ, ನೀವು objections ಹಾಕಿ. List on 27th objections if any by then. Next.
21 Chetan T Limbekai, Sajendra Kusma.
Let's order of dismissal called in question. Let's. The petitioner is a consultant. She was appointed in the year 2005, 23/12/2005. Let's on 22/9/2023, a show cause notice was issued to the present petitioner, saying that alleging that she has achieved poor performance in the work. For that, on 29/9/2023, she has given detailed reply to the said show cause notice. On 29/2/2024, she has terminated from the service without holding inquiry.
2014 or 24?
24. Your lordship covered by judgment on
The order of appointment.
when covered in last time I have your lordship covered by judgment. Sharda Dodmani minutes reported in 2023 SCC online care. Last occasion I have given. I'm also relying minutes another two.
Without inquiry ಅಂತ. Yes, sir.
My lords, may kindly see my lords annexure R4 at page number 10. The inquiry has been held as per the guidelines issued by the.
Where is the inquiry, sir? Show cause notice ಕೊಟ್ರಾ?
Yes, my lords.
Charge sheet file issue ಮಾಡಿದ್ರಾ?
No, my lords. This is the inquiry, my lord. This is a scheme which is, my lords, the appointment is under the scheme for Swachh Bharat mission.
How many years she's worked?
My lords, this is a contractual employment.
ಎಷ್ಟು ವರ್ಷ?
Since from 2005.
2005?
18 years.
Every year the contract has been extended.
ಆಮೇಲೆ?
Now, my lords, annexure R2 is the, my lords, guidelines issued by the state of Karnataka to assess the eligibility of the R2, page number 6. To assess the eligibility of the persons, my lords, who is engaged in this scheme. My lords, according to, my lords, these rules, my lords, they have to get a maximum 30 marks and minimum 15. If they come below, my lords, 15 marks, my lords, they are eligible to be removed.
When was the test done?
My lords, this is test, my lords. The guideline says, my lords, who has to conduct the, my lords, test My lords, as per the guidelines, my lords, the chief executive officer and project director and chief officer and executive engineer is quorum, my lords. Annexure R4,
We are not on that. You have deployed her in 2005,
yes,
terminated her in 2024.
yes.
The reason for termination is what I'm asking.
My lords, she has not achieved the, my lords, as per the guidelines of the state government.
What guidelines are they?
Annexure
Take
R2.
me to that page. Don't beat around the bush.
Please.
Yes. Where are the guidelines? Particular clause of that guideline.
7, my lords.
Page.
Page number 7, my lords.
Page number 7.
Yes. ಒಂದು ವರ್ಷ ಪೂರ್ಣಗೊಂಡು ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮೀಟರ್, ಒಂದು ವರ್ಷ ಪೂರ್ಣಗೊಂಡು ಸಮಾಲೋಚಕರನ್ನು ಮುಂದಿನ ಅವಧಿಗೆ ಮುಂದುವರಿಸಲು ಕಾರ್ಯಕ್ಷಮತೆ ನಡೆಸಲು ಕೆಳಕಂಡ ಅಂಶಗಳಂತೆ ವರದಿ ಪಡೆದು ಪರಿಶೀಲಿಸುವುದು.
ಪ್ರವಾಸ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
Stage number 7 in my lords.
I am at page number 7.
Statement of objection.
Statement of objections.
Yes, my lords. Yes.
ಸಿಕ್ಕಿಲ್ಲ ಅಂತ.
Let's after the table, they have given my lords, ಜಿಲ್ಲಾ ಸಮಾಲೋಚಕರು ಪಡೆದ
ಜಿಲ್ಲಾ ಸಮಾಲೋಚಕರು ಪಡೆದ
ಗರಿಷ್ಠ ಅಂಕಗಳು ನಿಗದಿಪಡಿಸಿಲ್ಲ 30 ಅಂತ ಹೇಳ್ತಾರೆ.
ಗರಿಷ್ಠ 30 ಅಂಕಗಳು 30 ಆಗಿರುತ್ತದೆ.
Please.
ಯಾವ ವರ್ಷಕ್ಕೆ ಇದು?
For the period of my lord 2023 and 24.
Oh, so 23-24 she did not achieve that target.
No.
Let's terminated.
That is according to.
In fact, my lords, in the year 2018 itself, she was awarded best worker.
Anything else?
Page number.
Notice kotra munche?
Please.
Notice kotra.
Yes, notice has been given.
What is this judgment, Thomas?
Thomas, my lords. Raghupati.
Raghupatiya.
Raghupati and Kannailal. 9, 10, 14 paras.
ಇನ್ನೊಂದು ಯಾವುದು?
Kannailal.
Yes, sir. The petitioner is before this court calling in question an order dated 29/2/2024 by which the third respondent terminates the service of the petitioner as a consultant of information in education and communication, which comes under the scheme Swachh Bharat mission. Heard so and so facts and brief germane are as follows. The petitioner is appointed as a consultant on 23/12/2005 in the respondent and is in continuous employment for the last 18 years. It is the submission of the petitioner that she has received several encomiums for the work performed throughout these 18 years. For the year 2021, the performance of the petitioner, according to the respondent, was not up to the mark. It is was not up to the mark. Therefore, a notice comes to be issued, and in reply to the notice, the reply submitted by the petitioner to the notice results in her termination. The termination has led the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that for 18 long years, the petitioner has worked in this scheme, and on 18 long years has worked with the respondent under the scheme, though the contract was renewed from time to time. Non-achievement of a target in a particular year cannot result in termination of the petitioner is the submission of the counsel appearing for the petitioner. He would seek to place reliance upon the judgment of the apex court in the case of K. Raghupati versus State of Uttar Pradesh, 2022 6 SCC page 346, to buttress his submission towards the quashment of the order. The learned counsel appearing for the respondent would seek to defend the action of termination, taking this court through a communication with regard to the scheme for appointment of persons under the Swachh Bharat mission. The communication is according to the learned counsel, In terms of the communication, one should get at least 30 marks in a particular year for continuance of their services, albeit on contract basis. He would submit that since the petitioner fell short of achieving the set target, so termination was the only option available. I have given my new idira. The learned HCGP would toe the lines of the learned counsel appearing for the respondent and would seek dismissal of the petition. I have given my anxious considerations. The afore narrated facts are not in dispute. The issue lies in a narrow compass. The petitioner is appointed as a consultant and information
And education.
consultant of information, education and communication coming under the Swachh Bharat scheme in the year 2005, and it has continued uninterruptedly for 18 years is a matter of record. A show cause notice comes to be issued on 22/9/2023 on the score that the petitioner has fallen short of achieving the target of 30 marks in a given year. The marks are to be ascertained 30 marks in a given year, which is said to have depicted poor performance of the petitioner. Till 18 years' time, there was no problem. The performance of the petitioner has been good, and in one particular year, it is said to have fallen, which the learned counsel for the petitioner would dispute. Be that as it may, non-achievement of a target for a particular year cannot mean that the person who has worked for 18 years in the scheme can be shown the doors on any known day, and on any known day without holding any inquiry or otherwise with regard to such performance. Even otherwise, the apex court in plethora of cases has held mere non-achievement of a target or the poor performance in a particular year cannot mean that the services of those persons who were employed even on contract basis can be terminated. In that light, the petition deserves to succeed and the orders impugned to be obliterated. For the aforesaid reasons, the following order. Raghupati ಹೇಳಿದ್ರಲ್ಲ?
Raghupati and your lordship judgment, my lords.
Allowed quashed. The petitioner shall be entitled to reinstate. ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ, stay ಇದೆಯಾ?
Stay it.
The petitioner shall become entitled to all consequential benefits that would flow from the order.
Obliged, my lords.
Yes.
22, Surabhi Kulkarni, Anand P. Saudi.
Lords, the petitioner is challenging the order of Kate at Annexure A, my lords, wherein the tribunal has ordered for payment of back wages to respond number 1.
Stay ಆಗಿದೆಯಲ್ಲ madam?
Please. So on the last occasion, your lordships were pleased to stay the matter.
Oh.
Well, it is stayed, my lords.
ನನ್ನ ಮುಂದೆ ಬಂದೇ ಇಲ್ಲ.
30th January, your lordship. It's been ordered.
ಯಾವ್ದು ನೋಡಿ ಮೇಡಮ್ ಮಾಡಿ. Emergent notice to the respondent.
Notice is already ordered, my lords. They've entered appearance.
But that is not, who has entered appearance?
Shri Anand Saudi, my lords, appears for respond number 1.
Awaiting the appearance of the first respondent. List the matter on 21st.
Interim order may kindly be.
Subsisting shall continue to the next date of hearing.
Obliged.
Number 23.
In this matter,
This.
I appear for the bank, my lords. I filed an IA seeking permission to deliver possession of the property.
To whom?
To the petitioner. He is the auction purchaser. Respond number 6 to 9, who are the judgment debtors. The award passed by the ARCS has attained finality. They are initiating collateral proceedings. Now they
That
have.
is stayed anyway.
It is stayed, my lords.
That is stayed.
Stay is granted of the proceedings.
Revision petition.
Revision.
Yes, before the cooperative minister, which are not maintainable.
Where is are they served?
Respond number 9 is served. He is the petitioner before cooperative minister.
ಯಾವತ್ತು served?
They've entered appearance. my
Appearance
lords.
has been entered on his behalf.
CB Sukanwali, advocate
Yes.
avara?
Please.
CB Shakunwali, yes.
All right. Heard the learned counsel appearing for the petitioner and the counsel for the fourth respondent. The ninth respondent is not present as a last chance list on Tuesday in the fresh matters list. In the event the ninth respondent is not present, orders would be passed on the submissions made by the counsel for the petitioner. Next.
Interim order.
Subsisting will continue to the next date of hearing.
Okay.
Sunil Desai, Vinod Pawar is without order.
ಏನಿದೆ?
No, this is. They cannot be reserved.
Where did it come in fresh matters now?
My lord, your lordship has posted it for further hearing and last date your lordship.
Readings are complete?
Yes, my lord. Readings are complete.
ಅದೇ ಟೈಮಿಗೆ ಬರಲಿ, ಬೆಳಗ್ಗೆ ನೋಡಿ ಮೂಮೆಂಟ್ ಇರಲ್ಲ. ಎಸ್ 4 o'clock.
4
on Monday ಇದ್ದೀರಾ?
Monday.
Tuesday.
Wednesday, Monday, Thursday.
No, not one. ಬೇರೆ ಇದಾರಲ್ಲ. You come and do it. Yes.
I'll make Thursday.
Yes.
Few decisions, citation.
Give it. File it.
Please.
Yes, next.
Your lordship, sir, Wednesday, which?
Monday.
My, please, your lordship, please.
No problem. No, they are there. Next.
Let's even serial number 158.
ಈಗ each case ಅಲ್ಲೂ ಏನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
Yes, fine.
My lords, may I just request, I appear for Mr. Dodegoda, fourth respondent. May I
Leave
request
here
it in 24 and 24.1, my lords, relates to Professor of Physiology post. I am the common fourth respondent. Both of the petitioners are fighting for getting my post.
Okay, yes.
My lords, I request if it is possible to have it on 19th. I'll file a synopsis before that and then I'll argue on VC.
All right, 19th.
Let's just on 20th.
19th at 4 p.m.
Request it on 20th.
Better.
Up to 19, I had some.
Monday.
This fine. 20th.
Monday you appear online. All right, so what? Monday or Tuesday, tell me.
Sorry, sir.
No, if it's in the morning, list won't go.
Yes.
But serial number 158 also is collected.
158.
8.
Tag serial number 158 also with this.
Today it is there, not same.
Yes, next.
Lord, it's Wednesday, my lord.
ಅಲ್ಲ ಯಾವತ್ತು ಟ್ಯೂಸ್ಡೇ ನಾ ಅಜಯ್?
Navata 19th.
Ajay,
Tuesday.
Tuesday. When you,
Next Tuesday 4 p.m.
Just one.
you said Wednesday, I don't know.
My lords, I wanted 19th or 20th, my lords, subject to
20th.
because 17th. My lords, I'll come on Tuesday. Tuesday I'll be on BC, my lords.
19th is fine.
19th, great.
4 o'clock, my lord.
4 o'clock.
25, Mallikarjuna Skirema.
Please, discuss for petitioner.
Intermodal ಇದೆಯಾ?
This is a writ petition filed by the bank, my lord. In this case, my lord, an application was filed under section 154 of the Income Tax Act, my lord, for rectification of the order, my lord. That came to be rejected, my lord.
Yes, madam.
My lord, I am here. My only question to the
Now I am
council.
seeking only for remand because, my lord, your lordship
Some
may.
file something, yes.
Yes.
The learned counsel, what's your name, madam?
Rupa Anavekar.
So and so.
Rupa and Tirumalesh.
For the statement of objections. List on 26th.
My
25th.
name may also be kindly
You
be.
may be directed to take notice, my lord, in all three matters.
Notice ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, sir.
Oh, correct. Learned counsel, ಯಾರು? Tirumalesh, huh?
Tirumalesh.
Learned counsel Tirumalesh is directed to accept notice for the respondent. Objections, if any, in the next 2 weeks. Yes.
My lords, they have to file a ITA before the division bench. I don't know why they have come here, my lords.
Service is awaited, man.
Post immediately after service of notice upon the respondent.
Number 1. That's one number 1.
Interim order subsisting will continue to the next date. Next. Like much same order. List after 2 weeks. Yes. Interim order subsisting will continue. Hey, first time ಬರ್ತಾ ಇರೋದಾ?
First time.
Very good. Same ಆರ್ ಎಚ್ ಅಂಗಡಿ ಆರ್ಡರ್ ಮಾಡಿ. ಆರ್ ಎಚ್ ಅಂಗಡಿ ಅವರು ಸುಮಾರು ಆರ್ಡರ್ ಮಾಡಿದೀವಲ್ಲ. Yes.
Number 28, Sunanda P. Patil.
My lord, it is under the Senior Citizens Act, my lord. Petitioner has immediately after passing the order by the Assistant Commissioner, he has prepared a writ petition before this honorable court. But this honorable court has directed to approach the DC. And,
Who are you?
I'm the son of the respondent number 3. Respondent number 3 is
Hello,
applicant.
who is directed to approach the DC?
This honorable court has directed to approach
By my order.
Annexure F, your lordship, page
My
number
order.
31.
Annexure F, page?
31, your lordship.
ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಇನ್ನು?
No, my lord.
Order again.
It is disposed of and that order was challenged before this honorable
ಅಲ್ಲಿ
court.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್? DC ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
My lord.
ಇಲ್ಲ ಇಲ್ಲ.
ಅದೇನಾಯ್ತು ಅಲ್ಲಿ?
That was dismissed. The appeal filed by the petitioner is dismissed. That's why that order was also challenged before this honorable court, your lordship, in this
Now,
petition.
that senior citizen is no more.
Senior citizen is
Senior
no more.
citizen is
No
no
more.
more.
Respondent number 3 died during the pendency of this petition, your lordship.
DC ಮುಂದೆ appeal is not
Not
maintainable.
maintainable.
That's so.
AC ಮುಂದೆ ಮತ್ತೆ ಹೋಗಕ್ ಆಗೋದೇ ಇಲ್ಲ. You are
ಆಗಲ್ಲ.
not a party before the assistant commissioner?
Please, ma'am.
ಅಲ್ಲ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಪಾರ್ಟಿ ಇರಲಿಲ್ಲ.
He was a party, my lord, but without affording sufficient opportunity, it was disposed of during the COVID period, your lordship. So
ಈಗ
the
ಸ್ಟೇ ಇದೆಯಲ್ಲ?
stay is there.
ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
My lord,
ಅವರೇ
he is dead,
ತಿರ್ಕೊಂಡಿದ್ದಾರೆ.
your
He is
lordship.
no more.
He is no more.
Then
my
we'll
lord.
close it.
Closed.
You are the only legal head?
Daughter is also there and wife is there, your lordship.
Huh?
Wife and daughters are also there.
AC ಮುಂದೆ ಯಾರ್ ಪಾರ್ಟಿ ಇದ್ದಿದ್ದು?
Only respond number 3. Father of the petitioner, your lord.
ಇಬ್ರೆ. Petitioner and
Petitioner and the
deceased.
respond number 3 are the only parties.
The petitioner is before this court calling in question an order dated 20th August 2024 passed by the first respondent, by which the order passed by the assistant commissioner comes to be confirmed. Heard so and so. The petitioner is the son of the third respondent. The third respondent is said to have knocked at the doors of the assistant commissioner, claiming relief under the Senior Citizen So and so Act. The assistant commissioner allows the application against the present petitioner, after which the petitioner is said to have approached this court in writ petition.
102-964 for 2021.
Page heading.
Page 22, annexure E.
In so and so, writ petition 102-964 of 2021. The coordinate bench directs the petitioner to prefer an appeal against the order of the assistant commissioner before the deputy commissioner. The deputy commissioner is said to have rejected the appeal. Why does he reject it?
Because the order passed by the assistant commissioner is legal and valid.
Holding that the order passed by the assistant commissioner is correct, or the order of the assistant commissioner does not warrant any interference. It is those two orders that are challenged before this court in the subject petition. During the pendency of the proceedings before the deputy commissioner, it transpires that the third respondent is no more.
No, my lord, during the pendency of this
Illa.
petition.
During the pendency of this petition, the third respondent has died.
On 16/9/2000.
And on 16/9/2024. Therefore, the proceedings before the concerned court instituted, before the assistant commissioner instituted by the third respondent is of no avail. And the petitioner, being the only person who was made a party before the assistant commissioner, is entitled to succeed in the subject petition on the twin score that the appeal filed against the order of the assistant commissioner before the deputy commissioner is honest in the eye of law, in the light of the order passed by the division bench in writ appeal 254 of 2024. The other factor being the senior citizen who had approached the assistant commissioner today being no more. In that light, both the orders of the assistant commissioner and the deputy commissioner stand quashed. All remedies available in law be availed of by the petitioner or the members of the family. Ordered accordingly.
29, Risha S. Naik, Vener Bhatpurki, Archana Maggu.
In this case, my lord, the second respondent has modified their own order, my lord, by imposing further fine of rupees 25,000, my lord. Petitioner is practicing advocate, my lord.
In ground, sir.
Without framing any charge.
Madam, objections ಹಾಕ್ಬೇಕಾ?
Objections hakila because we are the formal party because under section 35 of the Advocates Act, my lord, the order has been passed. Hence, the writ petition is not maintainable since there is alternative remedy under section 37, the Bar Council Act, because order has been passed under 35.
Yes, with liberty, madam.
And one more thing is that, my lords, that
Serious allegations are there.
serious allegations are there.
Appeal ಹಾಕಕ್ ಬೇಡ ಅನ್ನಕ್ಕಾಗತ್ತೆ.
Allah, what he is doing, my lords, 32 judicial seals, government seals, local body seals, notary, still he is putting board on his office notary. He is not at all notary by the central government.
Most decorated notary.
What Bar Council observed that the State Bar Council has taken lenient view on this man by debarring only suspended for 5 years.
Oh, ನೀವು ತಗೊಂಡ್ರದಲ್ಲ. You have not taken a lenient view.
So we have imposed cost of
And even,
25,000,
my
my
lords,
lord, to be paid
that he
within 2
preferred
weeks.
appeal against the earlier order. And that order is confirmed by the Bar Council of India.
ಈಗ 37 ಅಪೀಲ್ ಇದೆಯಾ?
Appeal.
ಇಲ್ಲ ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡೋಣ.
That only cost is imposed that in because he is not ready to undergo the suspension order is passed. He is saying that I am completed. That is his contention before this honorable.
The appeal available idre we'll send it. Otherwise we'll answer it. Yes, appeal is there.
There is appeal.
37.
Appeal 37.
The petitioner is before this court calling in question an order passed by the Karnataka Disciplinary Committee of the Karnataka State Bar Council on 24/8/2024. The learned counsel, Srimati Archana Magdum, appearing for second respondent,
Second respondent.
appearing for the second respondent would submit that the petitioner has a statutory remedy of filing an appeal as obtaining under section 37.
37 of Advocates Act.
37 of the Advocates Act 1961. 1961. In the light of the said submission, without going into the merit of the matter, I deem it appropriate to reserve liberty to the petitioner to knock at the doors of the appellate authority under section 37 of the Act in accordance with law, if available in law, ordered accordingly. Yes.
Sir, number 30, Ravi Hegde, SK Booty.
Lord, the order of suspension, despite, my lord, the allegation is, my lord, the bus containing almost 72 passengers. My lord,
Suspension.
It has.
So what?
It has been stayed by this court, my lord.
Stayed?
Stayed by this court, my lord, by order dated 26/11.
Yes.
In spite of that, my lord, it has not been implemented. Legal notice was issued.
That's all right.
And,
what is the ground for stay of suspension, sir?
My lord, stay has already been granted.
What is the ground for continuance of stay of suspensions?
My lord, it has already, they have already issued charge sheet.
So?
And enquiries, my lord, they have notified.
Stay ಯಾವ ground ಮೇಲೆ ತಗೊಂಡಿದ್ದೀರಾ?
Stay is, my lord, the bus was intercepted in between the stages. And when the bus was parked by him for head counting and issuance of ticket, without uniform, my lord, they have come and
What's the ground
inspected.
for staying suspension? Tell me,
My
sir.
lord, there is a circular issued by this, by the corporation at annexure F. It was totally violated in order to, my lord, twist the facts.
What circular regarding what? Yes.
Regarding how the checking has to be done.
Suspension ಹೇಳಿ ಅಂತಂದ್ರೆ
Suspension is.
Without jurisdiction, incompetent authority ಎರಡೇ.
I understand.
ಅದು ಎರಡು ಒಂದೇ, sorry. Nullified and incompetent authority ಎರಡೇ.
Nullified means, my lord, nullified here is.
That should be demonstrable, ಸುಮ್ಮನೆ ಹೇಳ್ದಂಗಲ್ಲ.
That is the reason, my lord, I have produced annexure F, which indicates that, my lord, how.
charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ sir, ಒಂದೇ ದಿವಸನೇ ಎಲ್ಲ ಕೊಡೋದು ಅವ್ರಿಗೆ.
Enquiry ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ, and the last occasion, my lord, this honorable court, my lord.
ಒಂದೇ ದಿವಸನೇ ಎಲ್ಲ ಕೊಡೋದು.
And my lord, 90 days already completed. This become infructuous, my lord. The writ petition
Won't become infructuous, but charge sheet, you continue with the enquiry. Anyway, is reinstated, let him continue.
No, my lord, they have not put me back despite the interim stay. I got issued, my lord, legal notice.
Vacating stay ಹಾಕಿದಾರೆ.
ಹಾಕಿದ್ದಾರೆ subsequently, my lord.
Tell me, sir, what are the grounds for challenge suspension? Tell me.
My lord, basically The suspension order, my lord, annexure G.
Inquiry ಎಷ್ಟು ದಿನ ಶುರು ಆಗಿ?
My lord, on 8/11/2024, my lord,
Complete
inquiry
it in another 2 months.
not yet completed, my lord.
Complete it in another 2 months. Substance allowance ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಕೆಲಸಕ್ಕೂ ತಗೊಳ್ಳಿಲ್ಲ, ಸಬ್ಸಿಷನ್ ಸಲ.
Substance allowance ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರನ್ನೇನ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ.
Substance allowance ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
But that time, my lord, get instruction.
Very difficult to decide cases. List on Monday in the fresh matters list. Yes.
31.
My lord,
And no ground for suspension, sir.
Monday, my lord, Monday, Tuesday, any next.
ನಾನು ಅಲ್ಲೇ ಬಂದ್ಬಿಡ್ತೀನಿ. Yes.
Lords, there are other suspension, I mean,
Wednesday.
petitions, my lords, wherein suspension order has been.
Why you don't pay substance allowance when suspension orders are passed?
Usually it will be paid, my lords. In this case, we'll verify. But my lords, there are other matters. Today, my lords, some 4 matters are listed, and there are another 6 matters, my lords.
ಎಲ್ಲ ಇವ್ರದೇ ಇರುತ್ತೆ.
ಎಲ್ಲ ಅವ್ರದ್ದು.
Yes.
ಇನ್ನೊಂದು ನೆಪ ಹೇಳ್ತಾರ ಅವರು, ಯಾಕಂದ್ರೆ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ನೀನ್ ಪ್ರತಿ ದಿವಸ ಬಂದು ಅಲ್ಲಿ ಅಟೆಂಡೆನ್ಸ್ ಎಲ್ಲ ಸಹಿ ಮಾಡಬೇಕು ಅನ್ನೋದು ಒಂದು ಕಂಡೀಷನ್. That condition is, my lord, not seen in any of the suspension order.
That we'll see. All those things we'll see, but you can't.
Yes, I quietly.
Order of stay. How will you not reinstate him?
Lords, in some cases, my lords, vacating applications are filed, and since.
In this case, my lord, he has been
Incorrect.
reinstated.
Wherever there is interim order, if you have not reinstated, then it becomes difficult.
In fact, I think one or two contempt petitions are also filed.
See all this.
No.
ಮಾಡೋದಿಲ್ಲ ಸರ್ ಅವರು.
By Wednesday.
ಏನಾದ್ರು ಇನ್ಕ್ರಿಮೆಂಟ್
All those 4 matters, I'll take it on Wednesday.
Please.
ಡಿಮೋಷನ್ ಮಾಡಿ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಮಾಡ್ಬಿಡ್ತಾರೆ.
Yes, next.
Number 31, Sharadam Patil.
Of mandamus, my lords, to consider the representation, my lords, at wide annexure C, my lords.
Who has 1 and 2 now?
Yes, OS, my lords. Only to
State
consider.
fire emergency service, why?
My lords, he was working as a driver, my lords. He died, my lords. His son had applied for, he had given a
Compassion
represent.
appointment.
Yes. He was a minor, my lords, while his father was dead.
Date of death?
My lords, the date of death is, my lords, on 4/12/2001, my lords.
2001?
At the
That is,
time
my
of
lords, since
death
he was
of his
minor.
father, your lordship, he was 10
I agree, my
years,
lords, there is a
brother.
delay, my lords. Only to consider the representation, my lords.
No, sir.
There is a delay, my lords.
I will not create a right or a hope in you that cannot be given in law.
Yeah, my lords. Earlier, my lords, a representation given in favor of the department, my lords. Since-
ತಪ್ಪು ಸರ್.
ಹೌದು.
ನಾವು ಈ ತರ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡದೆ ತಪ್ಪು.
ಇಲ್ಲ, only, my lords.
ನೋ ಸರ್. ಬರೀ ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್, ಅವರೊಂದು ರಿಜೆಕ್ಷನ್, ಡಿಲೇ ಹೋಯ್ತು, another petition.
ಇಲ್ಲ, delay also may be considered with the representation ಅಂತ ಹೇಳ್ಕೊಂಡು, my lords, we cannot.
No.
Since he is the only son, my lords.
Maybe.
ಅಲ್ಲ,
Maybe.
during the while working he died, my lords. The father died.
So ಅದಕ್ಕೆ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಬರದೆ ಯಾವಾಗ?
ಇಲ್ಲ, ಬರಂಗಿಲ್ಲ. I admit, my lords, within 1 year I could file also major ಆದ್ರೂ ಹಾಕ್ಬೇಕಾಯ್ತು, my lords. Since, my lords.
No.
Consider on delay also, my lords.
No.
Let them reject my representation.
No, that's not. For the heck of passing an order, we should not pass. This is not correct.
No, my lords, his son has filed an application.
Hey, maybe, sir.
There is a delay.
24 years ಆದ್ಮೇಲೆ where will we give a direction to consider your claim for compassionate appointment?
Yes. No, my lords.
For the sake of passing an order, we should not pass.
He was
So
a-
unnecessary hope to
ಇಲ್ಲ,
these people.
he was a minor at that time, my lords.
Maybe, sir.
He was-
If you see the latest judgment, Canara Bank's judgment, Supreme Court says hand to mouth ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಬೇಕು ಅಂತ. 24 ವರ್ಷ you have survived. Day for yesterday's judgment.
His mother was taking care of him. Now he is a major now.
Hey, what to do, sir?
Only on that ground.
Don't harp on this employment, secure employment elsewhere. The petitioner is before this court seeking a direction to consider the representation submitted on 27/3/2021 to first respondents 1 and 2. The petitioner, the father of the petitioner is said to be in employment. Employment in the Karnataka Fire Department.
The driver.
The father of the petitioner was employed as a driver in the Karnataka Fire Department. He dies in harness on 4/12/2001. At the time of the death of the father of the petitioner, he was 10 years old. Therefore, waits till he attains the age of 18 years and submits a representation on 27/3/2021 seeking an appointment on compassionate ground on account of the death of his father, which had by then happened 2 decades ago. The representation, reject madidara?
Consider
The representation is not considered by the state, and therefore the petitioner is before this court in the subject petition. The learned counsel for the petitioner submits that if a direction is issued to consider the representation of the petitioner, that would suffice for the present. What that would suffice? The learned counsel for the learned HCGP would seek dismissal of the petition on account of delay. What is sought by the petitioner is issuance of a writ in the nature of mandamus. For an issuance of a writ in the nature of mandamus, there should be a semblance of right upon the person who knocks at the doors of the constitutional court, and then springs the obligation on the part of the state. The petitioner is the son of a person who was employed in the Karnataka Fire Department and dies in harness 24 years ago today. The family has sustained for 24 years, and after 24 years, a direction to consider the case of the petitioner for appointment on compassionate grounds only on the score that when the death of the father had happened, the son was 10 years old, and now he is 25 years old, and it should be considered, will run foul of the judgment of the apex court in the case of State of Jammu and Kashmir versus Sajad Ahmad Mir, 2006 5 SCC 766. In the light of the aforesaid judgment and the unequivocal facts, the petition does not merit any consideration. Dismissed.
42, Manoj and Vikanana.
Requesting for a small accommodation. Did last, no, I'm not part of that. I filed wakalat. Last occasion, your lordship had directed them to produce the action taken against one of the employee.
Wrongdoers.
Wrongdoers.
Yes, sir.
They have served me copy yesterday night, your lordship. I need some time. WhatsApp.
Already imposed penalty, my lord, for ಗೊತ್ತಾಯ್ತು ಯಾರ್ಯಾರ ಮೇಲೋ ಕೇಳಿದ್ದಾರೆ ಇವರು.
One week time.
Monday ತೊಗೊಳ್ಳ.
Please.
List on Monday in the fresh matters.
Please.
33, Rupa R. Anvekar, Girish Kulmani.
Matter is pertaining to service. Matter is pertaining to service. We have challenged the order of commissioner who has passed the order without giving. Stay there.
Yes, Girish.
Please, my lords. My lords, the judgment in which the petitions are relying are pertaining to the orders on
The next
income
2
tax
weeks,
returns, my lords.
interim order subsisting will continue to the next date of hearing.
Maybe dispose of it with that in terms of that judgment.
Okay, Prashant Usmani.
Then suspension na? ಅವತ್ತೆ
There are other my lords.
ಯಾವತ್ತದು ಆ ನಂಬರ್ಸ್ ಕೊಟ್ಬಿಡಿ ಪ್ರಶಾಂತ್.
Please, my lords. 6 cases.
Yes.
Wednesday.
Number 35, Harish S. Naik.
My lords, 35 represent the petitioner's counsel, my lords.
The similar.
Senior counsel will appear.
My lords, 35 I represent the petitioner's counsel. This is the matter where during the process of interview, my lords.
Unmute. You're not audible. Madam, ಇಲ್ಲಿ problem, ಅಲ್ಲಿ problem.
Before your lords, may I submit your lordship? Similar matters are pending before the principal bench, your lordship. And the department engaged services of learned AAG, Robin Jacob. AAG.
ಗಂಗಾಧರ್ ಬಿಡಕ್ಕೆ ಹೇಳಿ.
ಅಲ್ಲ, ರಾಬಿನ್ ಜಾಕಬ್ ಅವರು ಬರ್ತಾರೆ. ರಾಬಿನ್ ಬೆಂಗಳೂರು ಬರ್ತಾರೆ.
Robin Allah.
Notification, my lord. In this petition, we have not challenged the notification, madam. This notification is not binding upon this petitioner
There
society.
is a detailed interim order granted. The only issue is whether you could change the rules of the game after the game had commenced.
Inter process is already
Please.
started, my lord.
Because notification was already issued, you could not have changed it. As
Your
simple
lordship,
as that.
learned AG is engaged in this matter, your
ಆಯ್ತು,
lordship.
ಯಾವ್ದು
So,
ಬೇಕು ಹೇಳಿ.
ಅಲ್ಲ ಅಲ್ಲಿ
Lords, may I make one
Bangalore
submission, my lords, if your lordship permits?
one matter from Gulbarga bench also is transferred to Bangalore bench. ಇಲ್ಲ, one matter, Kalburgi, sorry.
ಕಲಬುರ್ಗಿ ಬೆಂಚ್.
ಅವೆಲ್ಲ ಡಿಫರೆಂಟ್ ಇದಿದೆ.
ನಾನು
All the matters could be taken
No
up
problem.
together, your lordship. And
Heard the learned senior counsel K. N. Panindra appearing for the petitioner. List the matter on 7th March for further hearing.
70.
Please.
ಅಲ್ಲೇ further hearing 7th March. Interim order subsisting will continue till the next date of hearing. ಅವ್ರ ಏಜ್ ಅಲ್ಲೇ ಬರ್ತಾರೆ ನೋಡೋಣ.
Please.
36, Venkatnarayana GM.
Lordships appearing for the petitioner virtually, Lordship.
Reconnect ಮಾಡಿ. ಇಲ್ಲಿ ಅವರು. Reconcile.
Lordship, appearing for petitioner virtually,